So first I'm going to take roll real fast. Mustafa Belcora.
Yeah.
Here. And if I pronounce your name incorrectly, please correct me. Kyle Cagle. Mr. Cagle. Nowhere? Neither of you are Kyle?
No.
Okay, so no Kyle. Sarah Duarte Garcia?
Here.
Here, okay. Turner Gall? Turner Gall? No Turner, all right. Lucas
Yes.
Grosshead Pupendal, here. How do you pronounce your last name?
Yeah, not bad.
Okay, close
Hello.
enough, right? Mary Harb? Mary Harb, no? Daniel Jacob,
Yeah.
okay. I think I pronounced that right. Pim Jansons,
Yeah, I'm here.
okay. Alicia Lashova, Alicia. Christina Markfort. Here, okay. Gabriel Marquez. I don't know how to say the last name.
I'm here.
You're here. You're not going to tell me how to pronounce your last name.
It's called Dab.
Deb. Okay. I didn't want to say that because I didn't want to be like, am I right?
Yeah, it
Okay.
sounds weird, but that's it.
There you go. Okay. Thalen.
Here.
Okay. Donald. That's you. Okay. Recognize the voice. Ksenia Naidanova said she's not going to be here. Emmanuel Ola Louis. Oh, and some of you all might be out of the range of my camera here. Let's see, Emmanuel.
Yeah, I'm here.
Okay, couldn't see on the camera there. Let's see, Austin, you're here. And then Anaclete Rotic is not going to be here today. He emailed me in advance. Courtney, you're here. And then Gordon Zabrowski.
Yeah, yeah.
Okay. All right, first we'll just start with a few kind of, who we got? Okay, who just walked in? I'm sorry? Who just walked in? Who was it that just walked in the black? Name, please.
Yeah, Alisa.
I'm sorry?
Alisa.
Alicia, okay, thank you. So, Turner Gall's out, Kyle Cagle's out, Mary Harb is out. Okay, so we're going to start with just a couple of quick kind of housekeeping things. I know this has been an unorthodox start to the class and following an unorthodox year. I obviously wasn't able to be here for the first two classes because I was myself ill with the illness. So we're going to have a lot to cover today. So this class is going to be a little bit longer than it'll be going forward. That I think you'll make it through. It'll be okay. I've got papers, first case brief from 13 of you, which means that 6 of you have not yet turned in your case briefs, and that is not good. But you know, again, we did have an unorthodox start, so if you can get them to me by tomorrow at noon, I will still count them. You will get a small deduction in your grade for being late, but I will count them if you get them to me by noon tomorrow. No, let's say 6 o'clock tomorrow, 6 p.m. tomorrow. If you have not turned in your case briefs, get them to me by 6 o'clock tomorrow, and I'll still count them. If I don't get them by then, and you've not turned in your first case brief, you'll get a 0 on it, which will obviously have a significant impact on your grade. Good evening, sir. Are you Kyle or Turner?
Turner.
You're Turner? Okay. So, and I was just telling them, if you've not turned in your case brief, 6 of you have not, I'm not going to name names or anything, but if you haven't turned it in yet, get it to me by 6 o'clock tomorrow evening, and I'll still count it. You'll get a deduction in your grade, if a small one, but I'll still count it, and you'll still get the majority. If you do a good one, you'll still get the majority of your points for it. And then as far as the discussion posts, you know, this was kind of, we basically just copied the online course into Canvas because we sort of started it online because I was out. So y'all did great with the discussion posts. I enjoyed reading them, and everybody actually did the discussion posts timely, which was good. But going forward, you won't have to do the discussion posts on Canvas. It'll be strictly the discussion we have in class will be the discussion portion of your grade, which again is a significant portion of your grade. So you want to be sure that you do participate during class, because you won't have the opportunity to do it on Canvas. Now, if you have to be out of class for whatever reason, that could be, we've got a couple of students that had to go take care of personal business. If you let me know in advance, it's not a big deal. And what I will probably have you do to make up your discussion grade will be to just email to me directly a 400-word post on the discussion topics for the given week. You're still going to be expected to read the material on the discussion posts on Canvas, and they'll be part of our discussion in addition to the textbook reading. Now, does anybody have any questions about that? Does that make sense? Okay. And then as far as the first case briefs go, I kind of threw you all to the wolves with that, but I didn't want to delay it any longer. I didn't want you to have to write 3 case briefs, back to back to back to end the course. But it's also good to just kind of try it on your own, to look at examples of what other people have done, and then to just do your best and write your first case brief without me telling you how to do it too much. That gives me a good idea of, your skills and then deficiencies as a writer. And also it helps me determine, okay, what aspects of, analyzing and understanding Supreme Court opinions does a class need the most help with? And I'm sure it won't be much. I've not read anybody's case briefs yet, but I'm looking forward to that. And one note on the case briefs, and again, I've not read them, so I don't know if any of you all did this, but Supreme Court opinions are published with a syllabus at the front that's, I think for this, it was 4 pages for this particular, the main community health case. And then it'll have the majority opinion, and it'll start over at page 1, and that's the majority opinion. And then the dissenting opinion starts over at page 1. My class last year had a lot of problems with page number citations. 1, do not cite to the syllabus. The syllabus is handy to get an overview of, okay, this is what the case is about. Here are the major points, but you don't cite to the syllabus in your case brief. I want you to cite to the actual opinion to show that you actually dove in and read the 28, 30 pages of the majority opinion. So do not cite to the syllabus. You can read it, but just don't cite it. And also, you really only need to worry about the Supreme Court opinion itself for your case briefs. You don't need to, cite to a CNN article or a Fox News article, whichever side you like on that. I don't need the news articles, just your analysis and your opinion of the Supreme Court's opinion for whatever the case is for the given case brief. So are there any questions about the first case brief or anything I've said with respect to the case briefs? Now's the time to ask. And some of you had emailed me on Sunday, and unfortunately I did not get to my emails. So if you do have questions and it's like a Sunday and you got the case brief due, you all have my cell number. Feel free to text me. And if it's a long question, you can just text me and say, hey, this is so-and-so from bed 570. Can you please call me? I've got a question about the case brief. And that's not a big deal. I often don't have the opportunity to check my email as regularly as I would like. I've got work email, personal email, school email, and then farm email. I get all kinds of emails. I got more emails than I know what to do with. So texting and then calling, those are the best ways to get a hold of me if you've got, questions about how to do your case briefs or any issues you've run into with your case briefs or with any other issues in the class. So to give you all a little bit of background about myself, I'm an attorney, obviously, here in Knoxville. I practice in civil litigation primarily. I do some transactional work, wills primarily, and also some business work. But primarily I'm a civil litigator. And while I am a lawyer, and we're going to talk about the law, this is the disclaimer I have to give. Nothing I'm telling you in this course is legal advice and should not be construed as legal advice. And if you need an attorney, you got to go consult one. Don't try to ask me a question in class and be like, yeah, professor, that's interesting, but what about this car wreck I was just in? that's, you need to talk to someone in their capacity as an attorney. But, in this class, while we will be talking about the law, I'm not giving you legal advice. We are just talking about the application of the law to certain scenarios. So with that out of the way, I'm going to start from the top and go back to the readings you did 2 weeks ago, which I'm sure you all refresh yourselves on before class. So kind of the main themes of this course, we call it Introduction to Business Law and Ethics. You might call it Introduction to Business Law and or Ethics, because you probably saw from the first chapter's reading that, ethics and the law oftentimes are on the same path. Sometimes they take widely divergent paths. So let's start with kind of an example of that. So let's say you're walking down the street somewhere, and after a big rain, there's a puddle on the ground, and you see a baby lying face down in the puddle with his little arms flailing, and he's drowning. His face is totally submerged. Little arms are going. And if you don't save this baby, he's going to drown. There's no question. Do you have a legal obligation to save the baby? No.
If you're a doctor, you do, don't you?
Well, let's not talk about the narrow exceptions. Just the general rule is no, right? It is no. So is anyone here shocked by that you have no obligation to save the drowning baby? Nobody's shocked. You all have hearts of stone. So you don't have a legal obligation, a legal duty to save someone who's in distress. Now, morally, ethically, in that situation, would you have a duty to save the baby? Would anyone say you don't have a moral duty to save the baby? No. Morally, yes, you should definitely save the baby. But legally, you don't have to. You just keep walking, whistle your way on by, and that's fine. Now, why does the law not impose a duty to rescue? Anybody got any ideas?
You put yourself at risk in different scenarios and things.
Certainly, you could put yourself at risk. Yeah.
You also be liable if it didn't turn out well.
Yes. Now that's the big one. Strictly from a liability standpoint, if you undertake to rescue someone, but then you don't rescue them, or you make the situation worse, you are then guilty of negligence, because you've undertaken a duty upon yourself and you breach that duty by not saving the person. So that's one major consideration. The other one is that you might bring harm to yourself, which is in a way analogous there. You're increasing the harm, in that case to yourself though. Are there any other reasons why the law does not impose a duty to rescue? Anybody in Jefferson City? Now, can you all hear me okay over there? Just a faint nod. So, no duty to rescue. Why? Now, I think you've made the biggest point, which is, that you undertake a duty. By trying to rescue someone, you have then undertaken a duty yourself, and you expose yourself to liability. That's a major one. The other one is, how would you implement a duty to rescue?
You can't force someone to do stuff.
Yep, that's true. You can't undertake forcing someone to do something rather than, saying you cannot commit these certain acts. There's a difference between the affirmative duty versus the negative duty. As far as how in terms of implementing the duty to rescue, first off, would anybody change the law to say there is a duty to rescue? Maybe not broadly. Would you say under certain circumstances there is a duty to rescue?
If you're trained as a physician.
Okay, so if someone's
the Hippocratic oath, whatever that is.
okay, so if someone's a physician, you would say, okay, you have an obligation to to try to save somebody. Now, what if that somebody is someone's a physician, and the person is drowning. Maybe not the baby in the puddle, but maybe this person's drowning in a swimming pool. Because that person is a physician, should they then have a duty to go and rescue the drowning man? Okay. Because what if the doctor can't swim? He's not a good swimmer, right? And you also see, kind of the law, at least, it still does. It wants to maximize free choice for people. And I think you all kind of touched on that a little bit earlier with your responses, is that, you can't force people to do something they don't want to do. And the law wants to maximize freedom of choice. There are certain parameters, obviously, but, you don't want to force people, to undertake behavior or actions that they otherwise wouldn't, or that are otherwise objectionable to them, right? And that's really the kind of the overarching theme of the course, is that individual freedom versus duty to others. And we see with the no duty to rescue that the kind of the law falls on the side of individual freedom versus the duty to others. You've got but then you've also got, like individual independence versus interdependence, which is the interdependence of, within your family. You've got interdependence with corporations and with communities, and kind of how corporations and communities will interact with individuals, and how vice versa, individuals interact with them. So keeping on that theme, who remembers the Yania versus Biggin case from chapter 1?
Drowning guy.
Another drowning guy. We're keeping with the theme of drowning here. Does anybody remember the details of that case? I know it's been a couple of weeks.
Another strip miner came over and visited him.
Yep.
He went to start a pump or something, and made fun of the guy until he jumped in 16 feet down the sidewall.
Yep. Exactly. There you go. And then his widow sued the other strip miner who had maybe egged him on. You maybe could say, we weren't there. We can't say for sure. Now how did the court rule in that case? That's right. Yep. And the danger, now there's some important distinctions here. So the danger in that case, there's an open pit, 16 or 18 feet deep with water at the bottom of it. It's open and obvious, right? It's an obvious danger. It was just as obvious to Yania as it was to Biggin. He was like you said, he's a fully grown man and, in command of his faculties. And he knows he can see the hole just as well as Biggin. He decided to jump in it. Maybe Biggin said, come on, what are you going to do? Jump, don't be a coward. Probably shouldn't have listened to him. Guy's not much of a friend, but, he could see that it was dangerous, and he knew he didn't know how to swim. So why'd he jump? Well, he's not too bright, I guess. So the widow is not able to recover. Now, it would have been different if, let's say, over the top of that strip mine, there was a kind of a weak little cut, just a cover put over it. And let's say Biggin didn't say anything about the cover when it's going to operate the pump, and said, hey, go over there and help me set up this pump. I need you to go over there. And let's say Yanni walks over that little cover and falls through it. Would that change? Would Biggin have any liability at that point? You think he would? Now, why would he have any liability?
He didn't make him aware of the dangers. He wasn't presently aware of the dangers going on.
Yep, exactly. So if you've concealed a danger, and not necessarily intentionally, the law there's negligence, and that's usually these kinds of cases stem from negligence, not from intentional acts. But that would be a negligent concealment of a dangerous condition that he knew about and the other guy didn't. So that would change how the law would approach that situation. But again, in the general rule is there's no duty to rescue. And Biggin didn't have, even though Yanni was actually helping him out, and it wasn't just a stranger that he walked by, it was his buddy, he still had no obligation to go in there and help him. Because again, the law is not going to put an affirmative duty upon you to rescue someone. So again, you all would, Donald, you said, and you go by Don? Don, okay. Now you said you would revise the law of rescue within certain limits, maybe, or did you? I don't want to put.
No, I mean, you can't compel someone to act in a situation without having first discerned the
the situation itself.
Yeah. And you get, if you have these narrow exceptions, you start carving, okay, if someone's appears to be dying of a heart attack and you're a physician, then you have a duty to rescue. And if you're Michael Phelps and you see someone drowning, you've got a duty to rescue, that becomes the exceptions would just be, there'd be so many that it would be utterly impractical to implement it, right? I mean, that's one of the kind of balancing acts that, lawmakers have to undertake and society has to consider when they're weighing how much of a duty are we going to impose on our citizens for the overall good versus how much are we going to allow our citizens to exercise free will, to the greatest extent possible. And that's, and again, I know chapter 1 was a while ago, but John Stuart Mill, does anybody remember reading about him shortly after the Yania case, and his thoughts over, I think he was a 19th century philosopher, maybe 18th. But he was one that said the individual is sovereign over himself. And he said mankind are greater gainers by suffering each other to live as seems good to themselves than by compelling each to live as seems good to the rest. So that, and I guess that idea he's getting to there is you don't want to have just a kind of a tyrannical majority that says all people, we know how the best way to live and everyone else needs to conform to that. For free society, we want to have you live as you see fit, provided it doesn't cause harm to others. And that's the hallmark of a free society, right? Should that be the case? I'm getting emphatic yes over here. Or the Stephen Heyman's communitarian ideas, should that be the approach we take? Now, does anybody remember the Heyman coming up shortly after John Stuart Mill in the readings? When he talked about the reciprocal obligation to act for the welfare of the community. And the idea he's getting at is using the law to shape behavior, moral behavior or other behavior.
Whatever choice you make, you should accept that being your result as well.
Yeah, say that again, please.
Is that him saying, talk about whatever choices and results come from your choices, you have to be willing to accept that as well?
And was that Heyman? Now, even I'm not sure on that one. So I think he did. I think you are right that he did. Should we use the law to shape moral behavior? Do we use the law to shape moral behavior? Let me ask that. Do we? Anybody give me any examples of how we do that?
It's illegal to litter even if the litter doesn't hurt anything.
There you go. Well, does the litter hurt anything? Or does it not hurt anything? Well.
It's illegal to speed even if no one's hurt or drinking and driving.
Yeah, okay. So these are good. Now, those are examples of things that we are trying to legislate behavior. We're trying to change behavior through the law. How effective is it? Do people still drink and drive? Yeah, oh yeah. I know. I know a lot of people that have done that. Not me. People litter. I got a friend I went to law school with. He threw every one of his cigarette butts out the window. He'd save them just to throw them out the window. I mean, it was that bad. But, and why do people continue to engage in that behavior when they know doing so subjects them to, penalties or imprisonment? Now that I can't answer. But you see, there have been ways that the law has effectively changed behavior. Smoking used to be ubiquitous. We'd be smoking. If it was the 60s, we'd all be in here smoking. I'd be lighting one up, and we have ashtrays at every chair, and and that's everybody smoked, right? But now, smoking's not nearly as common as it used to be, and that was an example of where the law was able to shape behavior. Now, we don't need to debate whether tobacco using tobacco is immoral or not. But it is an example of where the law did effectively shape behavior. But again, the flip side to that is how much of that was social pressures and how much was the law just responding to social pressures or to information that, it turns out smoking's bad for you. But that's just, kind of a way to think about the law, how we use the law, and to what extent we should use the law to control behavior on a broad level. Now let's keep with that duty to, or no duty to rescue kind of general rule. There's a Podius versus Mayer's case. You might remember that one. This one's pretty brutal. Facts of this one were pretty rough. Drunk driver hit a motorcycle, hit a guy on a motorcycle, right? And then he died. They hit him. So he and two of his buddies are driving down. They've been drinking. And they hit a motor. They lose control of the car, swing into the other lane, hit a guy on a motorcycle. Then they hide out in the bushes and make like 35 phone calls to anyone but the police, right? And then his buddies are like, we weren't here. Don't ever tell anyone we were here. And they just left the guy in the roadway. And then the guy left in the roadway got run over by someone who couldn't see him because it was nighttime, right? So now, how did the court rule in that case? Anybody remember? Anybody? So the court ultimately did find that there was liability here. And the reason why, well, why would the court find liability here? We said they're general, there's no duty to rescue. But here the court said, okay, we have a general no duty to rescue, but here these guys are liable for the harm they caused. Why did the court rule that way?
They conspired to cover it all up, didn't they? I mean, that was part of it.
They did. Now, how much did that play into the court's ruling? I think it did play into it a little bit. Probably the biggest one was, one, they created the harm themselves, right? So that's a big one. You hit the guy. Now, you still don't have, now you do, so rules of the road. If you are involved in an accident, you can't leave, right? Even if it's a fender bender, if you just hit something and peel out of there, you've technically committed a criminal violation. Now depending on the severity of the crash, not a major one or potentially a major one. But there is a limited example or a limited situation in which the law is going to impose, you may not call it a duty to rescue, but a duty to render some sort of aid. Okay, whoa, let's not do that. Was it the other one? This computer's trying to restart. Not now, not now, man. Whew. We dodged the bullet on that one. Let's see. So we'll call it a duty to act rather than a duty to rescue, right? So this is where in that Podius case, they caused the harm. They conspired to cover it up, as Mr. Knabb said. And those were probably the main reasons the court ruled that way, but they also looked at a number of factors when considering, is this a situation where there's going to be some kind of duty to act or not? So they look at one, nature of the underlying risk of harm. How foreseeable is the risk of harm? How severe is that harm? You got opportunity and ability to prevent the harm. So that's sort of the Michael Phelps situation, guys drowning. Well, okay, is the law going to impose a different requirement on Michael Phelps? No, generally no, but there could be certain situations where like, okay, you've created this harm, there was a reasonable foreseeability of it. This person's in danger and you have the ability to save them. The law is going to say you need to act in this situation. And they look at the interests and relationship between or among the parties. The idea there is if it's a total stranger, we don't want to have to act to save every stranger we come across, even if it's foreseeable harm and we have an opportunity and the ability to prevent it. But if it's a situation where it's someone maybe they will. And then societal interest in the proposed solution. And that goes to the broader kind of theme of when society says, okay, now is a time that it is appropriate to act rather than to just walk by the drowning baby. Now, how good, and I think that was a New Jersey case, and you get a lot of weird opinions out of New Jersey cases. And, most of you all be in Tennessee. You don't have to worry about that too much. But it's interesting to think about in relation to the kind of overall themes of this course. So let's do a couple examples here. So an elderly woman has a stroke while she's out shopping. And this is an example from the book. And the clerk takes her to a store infirmary, which I've never been to a store that hasn't an infirmary, but okay, and leaves her there unattended for 6 hours, and her condition gets substantially worse. Is there any potential liability for the clerk or for the store in that scenario? Yeah.
He had the ability to prevent harm, and then he left her. So.
When you look at it in terms of one of the big exceptions that we talked about earlier is when you undertake to rescue. That's really the undertaking of duty. You've then put a duty upon yourself to render aid to this person. You've tried to address the situation, and then you abandon it. And then they're going to say, yeah, you have, but that is correct. You have undertaken a duty at that point. The clerk undertook a duty at that point, to render aid to this woman, and then said, you know what, my shift's over, I'm out of here. So yeah, there's probably going to be liability there. What about a psychiatrist? He's got a violent patient. He's this violent psychotic guy who says, he's just sitting there ranting about his ex-girlfriend. He's like, I'm going to kill her. I'm going to chop her up. I'm going to put her in my freezer. And the psychiatrist says, nope, session's over. Same time next week. And the guy just leaves and doesn't say anything about it to anybody. And the guy goes and kills his girlfriend. Should there be liability for the psychiatrist in that situation? Yeah. So, and part of that example was also that he failed to make sure he was properly medicated. So this guy not only liable, he's probably going to lose his license, right? So he's got, if someone tells you, even if you're not a psychiatrist, someone says to you, I'm going to go kill somebody and I can't wait to do it. You probably, you arguably, a very good argument that you've got an obligation to tell somebody about that, right? Think about Dylan Roof, right? He was the guy that shot up that church in Charleston in 2015. Well, apparently he had a friend that he had said essentially that he was going to go shoot a bunch of people and start a race war. And his friends even hid his gun from him at one point, but they never told anybody about it. Now, I don't remember if the friend ultimately had any sort of liability for it, but they knew, I think they did end up, kind of going and talking to the FBI after the fact, which doesn't do anybody much good. But, that's an example of where you are going to have a duty to act if someone is giving you, I'm going to go kill somebody and I'm going to do it soon. Now, if someone just says generally, I'm so mad I could kill somebody. No, you don't want to go turn somebody in for that. But if they're talking in terms of specifics, this particular person, I'm going to go kill this particular person, you're going to have a duty to act at that point. You can't just say, no duty to rescue, too bad for them, right? And then final example, your passenger on a train tells a conductor, I need immediate medical attention. You got to stop the train. What do you think on that one? Would the conductor, if he just keeps going, would he have any liability if that person had a heart attack? Don't think so?
Yeah, I would think also. There's a lot of variables in that. Right?
Yeah, there are. Anybody think yes? Yeah, that's a tough one because, a conductor, he's responsible for the whole train, is stopping it suddenly going to create danger for other trains coming down the tracks. He's got all the other passengers he's got to think about. But then at the same time, he's got to weigh, that's where that balancing test comes in. What's the risk of harm? How foreseeable is it? What can I do to prevent it? So and that's, now here's, and this is this really doesn't go in with the duty to rescue, but the BP oil spill. The book spent a lot of times on that. I think the authors of the book might be environmentalists. They spent a lot of time on the BP oil spill, which is bad. I fish in the Gulf a few times a year. The impacts were real, and it was a disaster, of epic proportions. Now, who recalls kind of the details of the BP oil spill? What happened? What happened there? Anybody remember?
Didn't they have the opportunity to install like certain safety measures that would have stopped it, but they decided not to?
Yeah. So they had, they call blowout preventers, right? And that's so the gas in the Gulf, there's a lot of natural gas and oil deep under the ocean floor, right? And that natural gas will act as like air bubbles that'll come out and you can have violent eruptions. And that's just, if you're going to drill for oil in the Gulf, you just have to know that, right? So they know this is happening, or there's a chance that this will happen. So they get these blowout preventers, but they don't want to put in the acoustic. Good evening. Mary Harb. Oh, okay, right. Okay. Let me make sure you got. Filling in slowly. So they didn't want to spend the money on the acoustic cutoff switch, which essentially, my understanding is if it would automatically trigger cutting off that well and keep, oil from just, we're talking about the BP oil spill. So we've gone back to chapter 1. We're kind of going all the way through chapter 4. I'm not, we're still in chapter 1, not doing a great job here, but we're going to do the best we can. So yeah, they didn't want to, and they actually lobbied. So regulate, I think Norway and maybe Brazil, there were a couple of countries that already required, if you're going to drill offshore in our country, you have to have an acoustic cutoff or acoustic cutoff switch installed so that we don't have these, disastrous oil spills that probably won't happen, but maybe they will. And BP had actually lobbied the U.S. government or legislators in the U.S. government not to require it, not to pass laws that would have required that. Now, if they had passed laws that required it and they had put them in, maybe this didn't happen. And but the BP oil spill is a good, I guess, way to introduce the 3 primary ethical schools of thought, or schools of thought for ethics, and then there are 2 kind of minor ones. So do they still have that blackboard thing on here?
Hold on.
View board? Is it this one?
No.
No. It's been a while. Oh, there we go. I can use this thing.
Yeah.
Okay. Now, can you all see the screen over there in Jefferson City? Okay, and you can see the board. All right. So what are the 3 primary philosophical schools of ethics? Deontology. Okay. All right, and what is, who's the primary proponent of that school of thought? Yeah. Yep. That's Kant. I think that's how the Germans pronounce it, Kant. But it looks like Kant. I'm with you. So what is the deontological school? How does it view ethics?
I think it's all about like protecting autonomy. Like, I think the classical example is like if someone comes up and says, "I'm going to hide here," and then a murderer comes up and says, "Where is that guy hiding?" You have to tell them the truth.
Okay. Now that example that is right, but what is what's kind of there's a 2-word phrase. I'm sorry. There's rights and duties, but we're looking in terms of how a deontologist views the world.
Greater good?
No, yeah, no, it's universal principles. Universal principles. That's the primary idea here, which is, now that goes to the example of the murderer chasing the guy, and you have to tell him where the guy hid, because lying is wrong regardless. You don't so much look at, okay, what is the potential impact of what I've done? It is, there are universal principles, absolute truths that we must always abide by. Otherwise, we are not living a virtuous and ethical life, right? That's kind of the broad overview. Now, you get into, I didn't study philosophy in college. I had a friend who did, and you can really get in the weeds with this stuff, but we just want the kind of broad overview of the deontology school is it's universal principles, whatever that is. Don't worry about that. And that's, again, that's the idea that there are absolute truths, there are universal principles, and we must adhere to them at all times, even where doing so creates a potential for harm. Now, what's the next one? Or another one? Utilitarianism, right? You remember who the guy is for that? The main guy? There's Jeremy Bentham. Now, I don't know if the book, I don't recall them, did they say Mills was a utilitarian? There you go. Okay. And Bentham's, and that's where I want you to remember kind of the main, deontology, Kant's the main guy, utilitarianism, Bentham's the main guy. There might be one or two questions on the final exam that get into that, but it's not, you don't have to know every detail, the whole breakdown of who taught who what. But so what is utilitarianism? What's the kind of the main idea of utilitarianism?
The greatest good for the greatest number of people.
Yeah. This is loud. Greatest hashtag of people. So with utilitarianism, it is, like you're saying, it's what is going to have the best overall effect for the most people. So with utilitarianism, some degree of harm or some even severe harm to a small number of people is acceptable if there's a wider benefit to everyone, right? What might be an example of that?
BP spill.
The what?
The BP spill. Hit him with a half, 500 million, what was it? $500,000 investment.
Yeah, for the
That small amount, which is as a percent of their annual profits, is really tiny.
that's infinitesimal. A lot of money to us, but that'd be like 1,000% of my of just a year. But that's an example of where the utilitarian approach. Now of course hindsight is 20/20, as they say, and of course if they could go back and do it again and be like, you're damn right, we'd spend $500,000 to save all the millions and all the negative publicity. Of course, BP's still doing fine; they're still making plenty of money. But the utilitarian approach would have said, okay, if the board of directors had looked at it that way, or if the the officers had said, we got to make this investment, it's going to hurt our bottom line for this quarter, but man, if one of those wells blew up and the Gulf was just full of spewing oil, we'd be in some big trouble. Turns out they were. They didn't take the utilitarian approach. Can't say they really took the deontological approach either, right? So what's the third kind of big school? That's one of the more recent ones. I consider those kind of, we'll talk about those, but that is one of them, but I'm looking at the big three, kind of the major ones. Virtue ethics, exactly. Now, where does that come from? Who came up with that? Yep. What is virtue ethics? What's the idea behind virtue ethics?
People develop their moral abilities. So,
How do they do it? By
training.
training. What kind of training?
Repeatedly exposed to demonstrations of decent behavior with families and communities.
Right. So when Aristotle, and of course Aristotle is when's that, the 5th century BC or something, a long time ago, right? And life was a little different back then. No cell phones. Everybody was kind of, you'd be the member of a city state, and that'd be the only world you ever knew. And so virtue ethics was in a way a lot easier back then to say, regardless of what their actual virtues were. I mean, these people were violent slave owners, but hey, at the same time, they had a cohesive single society, a culture that people could learn, and it would build on itself to learn, okay, here we have examples of what is virtuous, ethical behavior. So that's, how do we want to say that? What I was saying, they've developed moral abilities through kind of training and exposure to other people's behavior. How practical do you think the virtue ethics approach is in the 21st century? Not, yeah. Because societies were people kind of move around a lot, right? There's not really people aren't growing up in one set society where they don't have a lot of exposure to different ways of viewing morality or the world or the law, right?
They're developing more as individualistic as well.
Yeah, certainly. There's not a cohesive single way of thinking or way of living, right? So probably between these three, we'd say virtue ethics are certainly the most outdated. Now, does anybody have any thoughts on which of these approaches is the best approach to use when thinking about how laws, shape our society, or what kind of laws we should have in our society? It's certainly the most practical, right? And probably the most efficient. Universal principles sounds great in theory, but then the murderer example, you're like, I cannot tell a lie. He's right there. That's yeah. I didn't lie, but so yeah, utilitarianism is probably the most practical in terms of real world application. Yes.
Would an example of that one be like, let's say I'm a business owner and I'm thinking about raising everybody's salary, but it might affect me negatively. If I choose not to do that, does that go against the utilitarian?
Potentially. So there's always going to be multiple factors at play, right? Like how much do you do for the business versus how much your workers do for the business. And how important is it if you put yourself in a position, let's say with that example, you say, I'm going to cut my salary down to, $15 an hour, and I'm going to make sure everyone in my company gets to make all the money they need to make. But then your personal life falls apart as a result. You can't make your payments on you got a big, can't make your mortgage payments, whatever the case may be. And suddenly you're not able to contribute as greatly as you did. And you're like the most important person in the business. You're the owner. Then the business suffers overall as a result, right? Now that's kind of an extreme example, but that's the balancing act that you're looking at, kind of the analysis you're taking with the utilitarian approach. Overall, I'd say just generally, yeah, if you said, I'm not going to raise their salaries because, I'm not going to go into my bottom line, that does seem to it does run against the idea of we want to do what has the greatest impact, causes the greatest good for the greatest number of people. And if there's harm to the one, but it helps everyone else, generally the utilitarian approach is going to say that's what we should do. So there are two more modern schools of thoughts with ethics, and we've already mentioned one of them, free market ethics. Now, what is free market ethics? Well, first off, who's the big proponent of free market ethics? Yep. Now, what is free market ethics? What does that say? Or what is the idea behind free market ethics?
Companies should always do what's most profitable for them. They don't have an obligation to serve the community if it's their bottom line.
Yes, essentially, yeah. They now they do impose some like very limited, it's some very, I don't know what you call it, there's some limits on it. They say if you're not engaging, you're playing within the rules of the game. Essentially, you're not just engaging in active fraud, then that's okay. You know, but everything should be calculated to maximizing shareholder value. Corporations should be acting for the benefit of their shareholders to the exclusion of all else. Now, this is a 20th century kind of viewpoint. And it's obviously it's like, okay, why don't we say profits overall? How about that? So what do you all think about the free market ethics approach?
Not selfish, but maybe biased in it. I don't know if biased is my word.
Yeah, selfish is probably a better
I
one.
think selfish is it.
Selfish would be a better one. Yeah, I like selfish more. I mean, there's not saying it's all bad, but it certainly takes a more pessimistic view of humanity to a certain extent, and it prioritizes material gain over benefits to society, to people. So yeah, it is kind of it's one extreme, and then you have the other end of the spectrum, the final one, and the book doesn't spend a whole lot of time on this, but there's one other. Yep, ethics of care. Now, who is that?
Caleb
This is loud. Gilligan's Island, yeah. Now, what is the ethics of care? What is the kind of the idea behind the ethics of care?
I guess she's looking at women and men, and how they both perceive things, different points of views, because, I mean, I don't know if it's clear to everyone else, but to me, because I'm a woman, like, I'm gonna have a little bit different morals than maybe a man would. I'm not sure. That's
So I might be looking at it as, hey, listen, we gotta make some money off this deal. And you're like, no, we have to save the baby whales. Man, is that kind of an extreme example, maybe? Yeah, that's kind of that was her starting point. What she ultimately, kind of distilled that down into is, okay, we need to let go of these archaic notions of men view things one way, women view things another way. We can actually, all of us can view things from both ends, right? So it's kind of a focus on network of relationships and nurturing and reinforcing the ties we have with one another. So it's taking a very broad, societal approach to ethical, questions, right? So that's kind of the broad overview. Now, this is, when we're looking at different, we won't talk about this, a whole lot through the rest of the class, the course, but it is important to know these, especially these first three, and they give you kind of a ground framework for, approaching the different topics throughout the course. And so you can always, if you ever we're talking about a particular issue, maybe next week, and you say, well, professor, under the utilitarian approach, I think this. I'd be like, oh my gosh, you get an A. But so be thinking about these things. It will be on the final exam. It's not it's not a major deal, but this is kind of from the ethical standpoint. This is the broad overview of the kind of the philosophical aspect of this class. So do make sure you kind of stick that one in your memory for at least the next, 6 weeks. So let's talk a little bit about corporate governance. And I just want to, I'm sure all of you all know this just as well as I do. Can somebody tell me the general structure, just very basic general structure of corporations in the United States. You got three main categories, and what are they?
Profit.
No, in terms of, we're talking in terms of the people that make corporations happen, right? You've got three major categories of who controls and runs corporations. Shareholders is one. Board of directors. Yeah, officers, and they might call them managers, you know. So shareholders are going to have the least active involvement with the corporation, right? Shareholders are not going to be involved in the day-to-day operations. They're not going to be involved in the day-to-day kind of just decision-making process, but they are entitled to certain things. They're entitled to accurate accountings and financial reports, either once a year, sometimes it can be quarterly, but at least once a year. You know, they're entitled to dividends. Anytime dividends are declared, shareholders are entitled to a proportional share of their dividends, which of course they can choose to reinvest it, buy more stock. They can just take their dividends, but they're entitled to the dividends. They're entitled to attend shareholder meetings, which are not board meetings, of course, and they're entitled to vote, and that can be in person or by proxy. And they get to vote not on everything. They don't get to vote on, you know, should we add an additional bathroom to the factory, but they'll vote on who's going to be, who are the members of the board of directors going to be. They can vote on major M&A, mergers and acquisitions. And they get to vote on, you know, whatever proposals the board of directors might put forth to them. But again, shareholders, they're going to have, I know this is very basic information, but I just want to make sure everybody is, there's no confusion on this front. Shareholders are going to kind of be, they're the most hands-off, right, in terms of their involvement with a corporation. Then you've got the board of directors, and they're appointed or voted on by the shareholders, and they're going to kind of oversee the broad overseeing of how the corporation functions, runs its business, you know, what its goals are, and that kind of, those kind of things. Then you've got the officers and the management, and they're going to be responsible for the day-to-day, you know, running of the corporation, right? So that's just kind of, again, this should give you a broad overview of, okay, when we're thinking of corporations, and it's the same to a certain extent for LLCs and other business entities. You know, LLCs are becoming more and more common. They're very easy to, you get a lot of the, you don't have as much formality with LLCs, but the concept is still the same. So we're talking about corporations, and we're talking about social responsibility. Does anybody remember the Citizens United Supreme Court case from several years ago? Probably see it in the news a lot. Does anybody remember Citizens United? No, okay. That's the one where they basically said they just took the gloves off, corporations can just funnel money into political campaigns willy-nilly, right? So the basis of the decision was that corporations are people too, and they have just as much a right to exercise, you know, free speech under the First Amendment as individuals do. And that's where kind of, that was the main basis of the court holding that corporations can be heavily involved in politics and in campaigns. Does anybody disagree with that decision? Anybody think corporations should not be able to have unfettered, you know, kind of play within campaigns and the money they put into campaigns? Yes, to a certain extent. Anybody say no? Any no's? Okay. So to a certain extent.
Are you talking about when the company invests money for just to help other people out?
No, I'm talking about political campaigns here, strictly political campaigns. So that was the focus of that case, was these corporations can spend money, you know, to support a candidate or a political stance without any sort of limitation, right?
Well, if it's gonna affect, I think it goes back to those, ethics as well, but if it's gonna affect all business, business for everybody, small and large businesses negatively. Like, for example, I think Biden wants to raise the taxes. I'm not sure if that's going to happen or not, but somewhere around, I forgot what percentage, but for example, if he wants to raise the taxes on businesses so they can pay, I don't know, more, whatever, on the wealthy or whatever. And some businesses completely disagree with it. I don't think that they should pay money to, per se, like advocate or disagree with it or whatever. But I feel like they should have some sort of opinion, because they're huge, but maybe Gucci or Nike, some big company,
Yeah.
other people might, they might influence other people and get more votes that way.
Yeah. So that's, again, everything is a balancing act with law and ethics, right? So there is, corporations should have some say, hey, if these policies are going to affect these major corporations that employ, thousands of people, should those corporations not have a say in it? And the majority opinion, looked at it in terms of the individual. There's no question the individual has a right to free speech, can say whatever they want when it comes in the context of political campaigns, right? Now there are limitations on how much money they can put into it, but there's no restriction on their ability to advocate for one side or the other. And the idea is with corporations, it's a collective of people. It's a group of, one corporation is speaking for a wide group of people. But then the concerns on the other end are these corporations actually purchasing influence for themselves? Are they putting in all this money into a political campaign so that if their preferred candidate wins, well, then suddenly this law comes through that says, Nike gets all this great stuff, all these great benefits, right? Now, it doesn't happen exactly like that. They're more subtle than that. But those are the kind of the competing concerns. And that's where the dissent in that case was they took the view that, the individual has a right to free speech, but corporations, they quote Jefferson, he said corporations would subvert the republic. And maybe he's right. You were saying? Oh, it's the mass. I'm like, said something.
I was wondering what your opinion was on that.
Well, my opinion is that, you'll need to be thinking about these things, and I'm not going to tell you. But it's a tough question, it is. But I think there's a lot of truth to both sides of it. So corporations should not be prohibited from speaking just because it's a corporation and not an individual. But at the same time, corporations, there's a gross disparity in terms of the power that corporations have, and the amount of money they have. And, they have a far greater ability to influence, candidates or elected representatives than any one individual does, except, like Jeff Bezos or something. But that's the same thing, right? He's just Amazon. So there's no clear answer, I don't think. Most people are going to fall one way or the other. Corporations are bad and evil, or they're going to be freedmen, profit, corporations are the best. Let's make some money.
I think it also depends on like the core of the person. If they're just a completely selfish, bad person that knows they can influence a bunch of people that think that he's a great person, then goes back to what you were saying.
Yeah.
Like you would get everything.
Yeah. And that's kind of the risk with the Citizens United ruling, is that corporations will just start to control even more than they already do. But again, can we say they don't get any say just because, they're corporations and not individuals?
What do you think?
That's tough.
Government's kind of like a big, huge corporation.
Yes, I absolutely would. It is. It's like a big for-profit corporation, not for profit, definitely for profit. But the government they make their own rules, so they get to say, well, yeah, we're like the corporations, but we're the government. So it doesn't matter. Yeah. Yeah, that's a tough question, and that one's kind of the book doesn't spend a lot of time on it, but that's a topic that, we could spend hours talking about Citizens United, but we're not going to, because, we don't get too political here. Exactly. Yeah. So Corporate social responsibility, benefit corporations. They talk about how these corporations that are set up explicitly to benefit society in some way, they're not that important. We're going to skip over them because we've lost an hour here. So let's move on to the gig economy and independent contractors, right? So this was, I think, chapter 2. And they talk about the Lyft case, whether employees for Lyft, like in the Lyft case was Cotter versus Lyft, but the same kind of rules or theories apply to Uber and any similar ride sharing services, right? And the question there that these cases are getting at is, are these Lyft drivers independent contractors or are they employees? Now, how do you determine whether someone is an independent contractor or an employee?
In my opinion, I think an employee is whenever you have to be somewhere at a certain time, you have certain obligations or requirements you have to meet. An independent contractor, even though you have kind of obligations you have to meet, it's just you make your own rules. Like if you have a little bit of freedom with what you do, I feel like you can be considered as an independent contractor.
That is exactly right. Now the cases, in lawyers, we put it into 1, 2, 3, 4, look at these specific factors, but in a nutshell, that is what you're doing. You're determining an employee has, the employer exercises much more control over an employee, where that employee can, when the employee has to be there, how long they have to be there, how they do the job. If the employer provides the equipment and the tools, that'll often weigh in favor of finding that this person is an employee rather than an independent contractor. And you see this, these Lyft cases, that's kind of a more national approach. Each state is going to take their own approach to these questions because it's almost always going to involve state law. We do have the federal labor standard, Fair Labor Standards Act that's going to apply kind of overall, and that offers some guidance for it. But typically it's going to be state by state. However, having said that, most states have very similar tests. And that is really, if you boil it down in a nutshell, that's what it is. It's the level of control versus, the level of independence a person might have. So to look at the degree of control that the employer is exercising, the claimant's opportunity for profit or loss. And this is something the test, I think this was actually the Fair Labor Standards Act test. When you're talking about opportunity for profit or loss, so an independent contractor can lose money on a job. An employee, that's almost never going to happen. You're going to get your hourly wage or whatever. You came in, you did your work, and yeah, you can do a very good job, but hey, that's what you can do, fire me. Then yeah, they are. But you don't bear any actual loss other than getting fired. But like if you have to invest in equipment or additional personnel and you have to do it yourself to get this job done, they're typically going to look at that as you're an independent contractor. You're in charge of kind of running the show there. Skill level, if you're not very skilled, it's going to be very rare that a court would find that you're an independent contractor, because you're going to have to, if you don't know what you're doing, someone's going to be directing you and telling you how to do it. And so that's going to weigh in favor of this guy's an employee. That's a real quick, now you've got me rushing. I did that in 4 minutes. So with the gig economy, with independent contractors, we're going to visit this again in here in a little bit in terms of weighing between, there's an example, actually, no, you all did the one, the Galat versus Fox Searchlight. You already did you all did the discussion thing on that. The question there was, are these unpaid interns or are they employees? So it's a little bit different in terms of how you look at it, but in terms of whether they're an employee, that test is still the same. It's here with the unpaid interns, the question was, okay, are they doing things, are they learning from it? Are they, gaining, valuable skills that they can eventually translate into a career? But it's a very similar, how you approach it is very similar, right? Now, one thing the book talked about a lot is changing this kind of rigid approach, and Tennessee's changed it recently in terms of how, like in workers' compensation cases, and this can have very, significant impacts for a person if they say, if it's not clear whether they're an employee or an independent contractor, and then they come and they get hurt on the job, and their employer is saying, oh, no, you're an independent contractor, meaning I'm not responsible for paying for your injuries through the workers' compensation program of my state, that can have very significant financial ramifications for somebody. And so that's why this law is going to adopt these very rigid kind of checklists of, okay, how many of these boxes can we check off to say I'm an independent contractor versus an employee? But the book's talking about, we just have a flexibility, worker flexibility and economic dependence, that kind of economic reality, economic dependence, and the flexibility of the worker. Because with the gig economy, we're seeing that people are doing things. People don't really have careers anymore. They have jobs. And by jobs, I mean, you go and you do one job. That job's done. You move on, you try to find another job, right? You're not having a steady coming in every day and just making a steady paycheck, right? Do you all think, does anybody have any thoughts of that kind of flexibility approach? That's where instead of having a kind of a laundry list of factors to consider, should it just be hey, we should look at the economic reality, if you're dependent on it, dependent on this wage, and you should be considered, therefore being considered an employee because you're dependent on it. Does anyone think that approach is good, better, or worse? Better or worse?
I don't know, that seems, I would tend to lean towards worse is my initial thoughts on that. I mean,
Why?
especially like looking at the Lyft scenario, right?
Yeah.
So if I choose to spend more of my time working for Lyft, that makes me an employee versus if I choose to spend less of my time working for Lyft.
Yeah. So that's certainly something that's, how would you implement that? If you're like, oh, I just decided to, if I went on vacation that week and they're saying, well, it's awfully flexible here. You're probably an independent contractor. But then, so the flexibility test, that could work okay. But again, if you don't have those kind of a checklist of factors, it gets very difficult. It just kind of is up to the courts to just make up, and you go case by case and you say, well, this particular fact pattern has never come up before. We'll see what happens. There's a lot less certainty, in how the law is going to treat you, right? And also the economic dependence model, if we look at it, well, if they're dependent on it, then they should be treated as employees and get the benefits of these federal and state laws that protect employees. Well, I'm an independent contractor. The work I do as a lawyer is all 1099. But damn, if I didn't do it, I'm dependent on the money I make, right? So who's not dependent on, who doesn't have economic dependence, regardless of whether you're an independent contractor or an employee, right? So those tests, they sound nice, but probably not that effective. Flexibility, maybe, but again, it's going to be, you're just going to find out case by case. And then that economic dependence, well, we're all economically dependent, well, not all of us, but the vast majority of us are going to depend on however we make our money. So that's not really a good test, is it, for saying this guy's an employee versus independent contractor, right? And when we look at how we got to this point with the gig economy, and the book talks about the Nikeification, when Nike kind of, I guess, led the charge in terms of just everything getting moved offshore. They started to outsource more, started off with payroll. Then it goes to, we can outsource kind of our managerial, they outsource production. And eventually they outsource everything. And then you've got thousands of people in the United States have lost their jobs because it's all being done, overseas. And so that was kind of starting in, I guess, the 90s is when it really took off. But then you've got what's replaced Nikeification, that's pretty much played out, you could say, almost, is Uberization. And that's what I was talking about earlier, where the job replaces the career. Now it's everybody's just going, okay, when can I get this job, make enough money to make it to the next job, right? We'll look at just a few tests of these. We'll make it quick. So let's say there's a guy, Fernandez delivers pharmacies to Ken Ray's customers. He delivers pharmacies? I think pharmaceutical goods maybe is what they meant. He owned and operated his own vehicle, so he's delivering medicine. Owns and operates his own vehicle. He's subject to credit and criminal investigations before being hired, required to report at specific times and follow specific routes, and he was disciplined if he arrived later or failed to make deliveries as directed. So if we looked at the traditional test that we talked about in determining if someone's an employee or not, would Fernandez in this case be an employee or would he be an independent contractor? Mm, You think so?
Because if he's driving, is it his own pharmaceutical goods?
No, he's delivering them for people.
Oh,
Right.
yeah, he's
Yeah.
So it is independent.
But so here, the traditional tests they're going to look at. So one, the big thing you want to look at, so this is kind of the big trigger word for you here. If it says you got to be here at a specific time and you'll be disciplined if you arrive late, that right there, before you even look at any of the other factors, tells you this guy's an employee. You know, if you're controlling when someone shows up, and that's one thing, like I'm an independent contractor with my law firm. So if I don't show up at 8:30, I ain't gonna say anything. If I show up at 9:30, they're like, good to see you. Glad you could make it. Because they don't ever want me to be able to say, they told me I had to be there. So under that test, he's an employee. Under the traditional test, he's an employee. Now under the flexibility test that looks at, what kind of flexibility is a person. Again, that's that kind of broad, we don't know how it would really turn out. But under that test, that approach, do you think he'd be an employee or an independent contractor? Both? You can't be both. It's got to be one or the other.
Well, if he's working for a company delivering their products on their timing, then him being late is gonna affect them, not him.
Yeah.
So I feel like he would be considered more of an employee.
And I think if you look at the flexibility test, so that's saying is what kind of flexibility does this person have? Even under the flexibility test, again, it goes back to that, you be here at this time and you'll get fired if you're late. That's an employee. So even under the flexibility test, you're going to get the same result. So let's say delivery persons for FedEx, they are screened and trained by the company, and FedEx requires them to wear uniforms and use vehicles that meet its specifications, marked with its logo. And they assign routes, establish the time of pickups and deliveries. They provide loading, sales, and customer service operators. They set the prices, and they pay its drivers weekly and prohibits them from soliciting new customers. So are delivery persons for FedEx independent contractors or are they employees? Under the traditional test, you're looking at employees, right? You're controlling when they get there, how they appear, how they interact with customers, definitely. Under the flexibility approach,
Employee.
you think employee? Yeah, employee. So it's the same there. You think they'd give you examples that were a little different. So Arena leased a taxi cab from and drove for Deluxe Transportation Services. Although he could decide how many and which days he would work, Arena needed to work steadily to break even. He paid for gas, kept cash fares. Deluxe determined the routes, the manner of greeting passengers, how the limo should be kept clean, and it arranged pickups and determined the fares. So under the traditional approach, what do we think? Employee or independent contractor? Independent? We're saying independent? We say independent over there? Yeah, so,
You can lose money.
yeah. So we think independent contractor. I think that's for sure. If he says, I'm not going to work today. And they say, okay. That's usually going to be an independent contractor. Under the flexibility test, yeah, probably get the same result. So you're seeing there's not a whole lot of difference here with this flexibility test, but I'm sure you could come up with a lot of examples where it'd be clear under the traditional test, you'd get a clear answer one way or the other. The flexibility test, you get to where you're like, you're not really sure. So how important is that topic? It's important to understand it, especially as you go off into the business world. You're going to need to know, if you're going to have employees of your own. Hopefully you'll one day, I remember that lawyer one time talking about independent contractors and an employee, and I'm telling these guys they have to show up at a certain time, but I want them to be independent contractors. Maybe I'll tell them to show up whenever they want. but then maybe that won't work. Maybe you need them to be employees. But it's important to know that the law makes a distinction between them. Employees enjoy far greater protections. And that's kind of the trade-off with having more requirement or kind of having more control exerted over you by your employer, right? Yes.
So franchisees, I know that kind of doesn't fall under that category, but let's say there's McDonald's and then people buy McDonald's franchisees and open their own. I guess they can have their own rules besides the.
So with franchise, it's a little bit different. And that's kind of, with independent contractors, employees, you're talking about people, right? With franchisees, you're talking about, it's a business, they're open, I'm going to open this McDonald's franchise. Those will be dictated primarily just by the franchise agreements themselves. There are certain laws, different states will have different laws dealing with franchises. But generally that's going to be dictated or controlled. That relationship is going to be controlled by the franchise agreement. So McDonald's says you can have a franchise, but you have to, your logo has to look exactly like this, and you have to serve all these things on your menu. I mean, you don't get a lot of leeway in what you can do. You're just trying to get a share of the profits, and you run that location on their behalf is how that usually will end up working out. So it's a little bit different. It's analogous in some ways, but there's not, again, it's really going to be dictated by what the agreement says between the franchisor and the franchisee. So Uber and Lyft. Let's talk about location data. And this is, some of you all did do the discussion post for week 3, which was good. But let's just talk briefly. You all read the New York Times article and the Business Law Insider articles about location data and how all these apps, there's just a huge number of apps that will track your data. They'll track exactly where you've gone, and then they will compile that data and either use it for their own ads or they'll sell it to other people so that they can sell you ads. So there's the one, what was the example? I can't remember which article it was, where they said, they know, she said she could tell you, okay, you like to Google healthy recipes and stuff, but I know that you go to fast food restaurants 5 times a week. And you're like, well, why do you need to know that? Well, you consented to it, is what their answer to that will be. But it's, and there's one quote from a woman that was really kind of scary. She said, we want to know where you've been and where you're going, and that can help us control what you're going to do next, right? So you want to talk about ethical considerations there. Should these companies, these apps, should they be able to track you on your phone and know where you are pretty much at all times? No? Yeah, anybody say yes? Wait, does anybody think that companies should be doing this?
I think
Yeah, it's creepy, isn't it?
you're a business person that's solely doing it for your business, no other reason at all, then maybe, but it is a violation of somebody else's privacy. It's kind of creepy too.
Yeah. Now, when we say it's a violation of a privacy, there is something, of course, you download the app. Would you like to turn location services on? And you say, no. They're like, well, this will help us get you all kinds of great deals. And you're like, oh, well, okay then. And you don't read the fine print that says, we're also going to package that up and we're going to sell it. You know what? Yeah, that's it. They're like, hey, click if you want to use this. Nobody reads it. The lawyers don't read it, like literally nobody reads this stuff. And you've agreed, and some people take the view that, hey, you hit accept. It's like, well, it's not like they made you scroll through and read it and then hit accept. They just said, you want to accept? By the way, here's our links to our terms and conditions page. But who's going to click on that and read that? You all have enough to read for your classes. So it raises an interesting ethical, not dilemma, but an interesting ethical question, right? You what?
I click on them, but I always give up.
Yeah. It's just like, hey, eyes glaze over. Like that's we lawyers, we do that on purpose. Make it real dry, and then the important stuff's deep within it. I'm like, oh, you agreed to let us track your every waking moment and your sleeping moments too. But you see, and you get the conspiracy theorists that think the government's tracking us and so they know where we are. But what it really is corporations are tracking us so they can sell us more crap, right? I mean, stuff, wonderful stuff, right? So, does that, do those privacy concerns outweigh the benefits that these apps provide?
Yes.
Yes. Does anyone say no? Who's got a great app that's like, you know what, this app is so good that you can just track me wherever you want?
It can't exist without it.
Yeah.
It's like that person in that position though, that, let's say I was being tracked and I didn't like it, I can make a big fuss about it, but if I was in the business person's position, I'd want it because information is power.
But you're not entitled to it.
You're not entitled to it. You're not, but.
Unless you hit accept on those terms and conditions.
Decided not to install that for that very reason.
There you go. Well, see, you're thinking about that, but most people, they're just like, accept, sure, I'll accept. Yeah.
But you're
So,
right, if you choose accept, then your case is valid.
yeah, you
But if
can't,
But if I haven't consented to that, then ain't no way.
Yeah, no, that's a different story. If I don't consent, yeah, that's definitely a violation of.
Yeah.
Privacy, but if it's just solely for how to making more money, then I feel like. since you accept it, it's okay.
so you take the free market ethics approach here.
Maybe
Like, listen, as long as it makes my shareholders a little more money, who cares? And that is, there's this corporate, from the business standpoint, I mean, to be fair, they've got a responsibility to their shareholders. We've got to increase our bottom line. If we can use this technology to reach more customers and to sell more of our product, then we're fulfilling our obligation to our shareholders. The flip side is, how many people know how much tracking is going on with their phones? It's the buried in the terms and conditions, when you say, wait a second, I didn't realize it was going to be, was this extreme. And then there's, with those privacy concerns, how well do businesses protect that information and protect that data? And even what if they've got one of their data analysts is like went through a bad breakup and then all of a sudden he knows how to track his ex-girlfriend's phone, right? And then goes and does something loony. Should the corporation have someone, if whatever data tracking firm he's working with have some sort of liability in that case?
And they're talking about the multiple resales, right? So
Yeah, well, and
it's
you,
data laundering.
yeah, it's who,
Used for this purpose or whatever.
yeah, that came, you downloaded the hot dog vendor, find me the closest hot dog cart. And then they sold that off to, some other corporation. They turned around and they sold it to another corporation before, and you don't know, where this thing all started from. You're being tracked by company Z when you download an app from company A.
It feels like data laundering.
It is. Should that be illegal?
My dad owns a business and I'm kind of doing the marketing section of it. And I was talking to this company called Blowout, and we were going over how they pretty much track data. One of the things is they can see how many times somebody clicked on our website. But we never have a thing to say, yes, I agree for you to check how many times I click on something.
Yeah.
That's a violation.
Now, website traffic. See, there's a difference between these articles we're talking about, they were tracking like where people were going. Like they knew this woman went to the middle school and then went over to her psychiatrist and then went and stayed with her ex-boyfriend for overnight and all this stuff. And then New York Times is like, can we put this in an article? And they're like, sure, this is scary. I want people to know. Then why do you have the Times publishing it? But whatever. Noble sacrifice on their part to expose this. But website traffic's a little different, so it's like I can tell if you've clicked on this website a certain number of times. Well, you could be doing that anywhere, but you don't know where they were unless you can tell, hey, they clicked on it while they were laying in their bed at home, and then they clicked on it when they were at work. These people are obsessed. They really like our website. But that sounds like you're just looking strictly at website traffic. I think that's something that's, from an ethical standpoint, that's totally fine. It's like if you had a brick and mortar and every time somebody walked in, okay, this is the fourth time this guy's been here this week, right? It's that kind of idea. As opposed to, you have a brick and mortar location and you're following one of your customers to the middle school and over the psychiatrist's next boyfriend. And you're like, why do you need all that information? And to to make our shareholders more money, is what these corporations say. Now, I'm sure, and I don't know if this happens as much now, but, if there was a long time where people would say, you'd be having a conversation about, I need a new leash for my dog, he's chewed through the old one and yada, yada. And then you look at your phone on Facebook and you've got an ad for dog leashes. Used to happen. They're just, now that's scary. That's much worse than them just listening to you.
Oh, I really want to eat so-and-so, or I really want this. And then it'll just happen on my phone, like an ad will pop up. And I'm like, okay.
It's a little scary. But again, it's, is the government using it to control us? It doesn't seem to be yet that we know. But these corporations are definitely taking advantage of it to make more money and to reach more customers. And again, it's fair to say these businesses are using the legal tools that are available to them to try to increase profitability. So that's where, and then you got some people that they don't care. They say anyone can know where I go as long as I can get my Chick-fil-A app, and that's kind of a personal decision for them. But I guess the question is, should we have restrictions on how these companies use data and whether they can sell it? Does everyone think yes? Yeah. Everyone think yes over there? Yeah. Yeah. They're not listening. But so.
Kind of like corporations having larger voices than individuals. I mean, yes, they have a voice. Yes, they have access. Some information is available, but too much, not so much.
Yeah. And that's, I think that's very true. And that it's just increasing the power disparity, between, they can pour all the money they want into elections. They can track you wherever you go. It's not the government we need to worry about, right?
Is it computers that track it, or is it like different people?
It's apps, or I guess they have, yeah, I don't know how the intricate details of how it actually works, but my understanding is it logs that data, whoever developed that app, it sends that data to them. They can compile, okay, this user with this identifier, we can map out exactly where this person was over the past week, and they can sell that to, Chipotle or whatever. They can, but the Supreme Court actually addressed that, I think in 2014. I think, well, actually, and the book is is a little disjointed, and I kind of wanted to address this later on, but we'll come back to that because the Supreme Court did address it in the context of, criminal investigations. There are certain limitations on what the government can do. Doesn't seem to be, kind of corollary limitations of what corporations can do. And that's the ethical dilemma with corporations using location data. So let's get into chapter 3. That's finally, we get into the readings for come on, we're like halfway through, guys. Whistleblowers. Who remembers the Sullivan versus Harnish case? Probably not saying that. Anybody?
Something about stocks.
Stocks are involved. Good. So this guy's he works for a hedge fund, right? He's the CCO. He's the chief, compliance officer or whatever. And the CEO of this hedge fund was engaging in private, securities transactions, buying and selling stocks, and not letting the hedge fund customers know about it. He was basically profiting off of what he would have knowledge kind of in advance of what's going to happen. And before saying, hey, you guys need to buy this stock, he'd be like, I'm going to buy this stock. Then I'll tell the customers later. CCO comes to him and says, listen, you can't, this is wrong. This is ethically, wrong that you're profiting and not letting the customers know. Like, we're a hedge fund. We're supposed to be working on behalf of our customers to make them money. And so they fire him for they just are like, well, you know what? We don't care, and you're fired. I don't know if it had been played out exactly like that, but essentially did. It's because he called out the CEO and he said, okay, then you can pack your bags. And he sued them after he got fired. And he said, I was fired because I was trying to expose wrongful conduct by the CEO. How did the court rule? Did the court rule in his favor and say, you are a whistleblower and you're entitled to, money damages? Or did they say, sorry, whistleblower statutes don't apply to you? Anybody have any ideas? Uh-huh. Mhm. They did. They said here, so he had argued that the legal and ethical duties imposed on, on investment managers, investment bankers justified his lawsuit against his company. He said, look, they were engaging in unethical behavior. And I pointed out to them, and they fired me because I did that. Case was dismissed because, why was it dismissed? I remember. They compared it to an older case, not that much older. It was the Weeder versus Scala case. That involved a lawyer at a law firm. And they distinguished it. The Weeder versus Scala case, this lawyer came in and said, you're engaging in unethical behavior. And here's the specific, rule of professional responsibility that's applied to lawyers and law firms that you violated. I don't remember the exact details of it. They were probably stealing money from clients. How those things usually happen. And in the Scala case, the court said, you were fired, but you were a whistleblower. You're entitled to money damages because you were fired for trying to point out wrongdoing. And it's a specific, they looked at their ethical obligations that the law and that public policy imposes on lawyers, right? So you're going to say it will erode the public's trust in lawyers if, we don't punish this kind of behavior. We don't allow a whistleblower to recover damages against this law firm. Didn't do the same thing for the hedge fund. Did they make it clear why? Not really. Not too much. Because essentially the court, they kind of took the easy way out on it. They said, well, in the Scala case, there's this specific rule of ethical responsibility, professional responsibility that all lawyers are required to abide by. So they say, if we can point to this specific violation, okay, that's a proper whistleblowing activity. You're entitled to damages for reporting it. You got fired for reporting it. You're entitled to damages for getting fired because you reported it. With the hedge fund case, it's kind of, they basically punted on it. They said you can't articulate a specific, ethical provision, a specific statutory, provision that says this guy can't engage in this behavior. We may view it as morally unethical, but legally there was, you haven't met the requirements of a whistleblower. And with these whistleblowers, it was the same kind of thing with that pharmaceutical case, the Pierce versus Ortho Pharmaceutical. They were working on this drug, and I can't remember what exactly it was for, but it was loperamide. And the research this doctor had been doing said, this drug is a carcinogen and it's going to cause cancer, and we cannot be using this drug, to develop this new prescription medication for approval by the FDA. We can't do it. We can't test on people. It's going to cause cancer. It's morally, it violates the Hippocratic Oath for me to engage in this testing. And she went and repeatedly went to the company and said, you can't be doing this. We can't be using this drug. They said, you know what? Yeah, we can. You're fired. In her case, did the court rule in her favor that she was a whistleblower who got fired for her whistleblowing activities and therefore was entitled to damages from her previous employer? Yeah, they ruled against her, but they recognized a new cause of action. They said, okay, and it's a little bit confusing. That case is a little bit confusing how they did that. They say there can be a cause of action, for whistleblowing activity, for blowing the whistle on corporate wrongdoing or with these drugs. But they said in this particular case, you know, she did it before it went to the FDA. They hadn't submitted it to the FDA. And they basically said, while this would normally be appropriate, the court is essentially saying, we need to allow companies to experiment with different drugs. They've got the FDA to oversee, kind of regulate how they do it. So in this particular situation, if she had come after the fact, you know, and they had been hiding something from the FDA, that would have been totally fine. But here, just because she was morally opposed to the use of loperamide in these drugs and in these tests, well, that's too bad. That's not enough. But they did recognize a new cause of action. That's like moral victory. It's like Tennessee football, moral victories, you know. No UT fans here, are there? Oh, wow. Me too. I was recovering.
Basketball season.
Yeah, that's right. We're a basketball school. Well, we were. Now we're not. And so there was also the, let's see, the Winston versus Bank of America case. Anybody remember that one? No, nobody remembers these cases. Well, the important thing to know with whistleblowing is the courts clearly are very narrow in how they view these. They won't say just broadly, oh, you blew the whistle, good for you, here's some money, right? They're going to be very specific in terms of their state statutes, which vary from state to state. So there was the New York statute, section 740 of the New York Health Code. And it said you cannot be, how did they said it? What did they say specifically? Yeah, let's look at that's question 8 on that Sullivan case, or I'm sorry, on the that Pierce versus Ortho pharmaceutical case. You know, looking at the New York labor law. No, that was the Sullivan case. They're asking that. So New York labor law, it says essentially, and I don't have it right in front of me here, but that if you go to your employer or go to a governmental entity or report either within the corporation or outside of the corporation that they're engaging in conduct that is likely or will cause harm to the public health and safety, or to, you know, the safety or the health of the public, and you get fired as a result, you can then sue your employer and recover damages, right? Taking that law, if they violate, they're doing something that is causing or will cause harm to the public safety or to the public health, would that have changed the outcome in the Sullivan case? That's the hedge fund case. Would that New York law have protected him and enabled him to win his whistleblower lawsuit? What? Yeah, so the New York labor law says you report activity that a corporation is engaging in that will cause or has caused harm to the public health or to the public safety, and you get fired as a result, you can sue your employer and you can collect damages. The Sullivan case, that's the hedge fund case. Would that New York labor, that law, that section 740, would that have enabled Sullivan to win his case if he'd been in New York? No, right? Because the harm or the unethical behavior that he was attacking was this guy was, you know, making stock trades to make himself some money, right? Is that endangering the public safety or the public health? No. So, and you know, that's just one specific example of a particular state's whistleblower statute. And you can see how, you know, the law is going to say, okay, in New York, we say if a company is somehow endangering public health or public safety, we want people, employees of that company, to come tell us about it. We want them to blow the whistle on it, right? But it's a pretty narrow exception. It's just if it's endangering public health or public safety, not if they're engaging in behavior that is, you know, illegal or is defrauding somebody or is, you know, unethical. It's pretty narrow, and it's pretty specific. And that's, you're going to see courts are going to limit themselves to the exact language of the statute. So sometimes legislators sometimes draft laws that are poorly worded, or they don't take into account every possible factual scenario where they would actually want people to have whistleblower protections. And so that's where you can see, and that's important to know from your all's perspective as future MBA masters of business. that in what context and in what situations can an employee blow the whistle and then come after you and recover money because of it, right? And so they also talked about the Montana retaliatory discharge, and these are two sides of the same coin. Retaliatory discharge is where it means exactly what it sounds like, which is they're firing you because your employer fires you because you did something and they didn't like it and they're retaliating, right? So Montana says a discharge, if you've been fired, it's unlawful if it is retaliation for the employee's refusal to violate public policy or for reporting a violation of public policy. Or if your discharge was not for good cause and the employee and the employer had completed the probationary employment period, or the employer violates express provisions of its own written personnel policy. So again, there's a little retaliatory discharge, a little bit different from whistleblowing, but it's the same kind of idea. So Montana's law that's pretty broad, right? Whereas you look at New York. New York says if it violates public health and public safety, then you've got a whistleblower case. Montana is pretty broad, public policy. When you say public, now of course they have that specifically defined within the statute, but it's still pretty broad. And you say, hey, this violates public policy, and you tried to report it, and they fired you for it. That's retaliatory discharge. You got a case against your employer, former employer. That's a really broad standard. And that's, where it's important when you're starting a business to know where are you, what state are you in, how many states are you going to operate in, and what the laws are. Now, of course, you aren't going to be lawyers. You don't have to go look up these statutes, but those are issues you need to be aware of, be cognizant of. And so when you're setting these things up, you can say, okay, I know if I'm in Montana, and if I get a disgruntled employee and he goes and says something, like there's a chance that he might make himself a case, if they can kind of stretch that argument, violates public policy. Whereas if you're in New York, as long as you're not endangering the safety and health of the public, you're in pretty good shape. You can pretty much fire your employees with impunity.
Is that one of the reasons Delaware is a very popular state for corporations to
Not so much for the retaliatory discharge, because again, that's going to be dictated not so much by where your corporate headquarters are as it is by what your location is. So you could be a Delaware corporation, but you really run out of Tennessee, or say you run out of Montana, you incorporate in Delaware, but you would still be subject probably, I'm almost certain you would still be subject to Montana law with respect to your employees in Montana. Yeah. Now, the reason that corporations or that businesses like to incorporate in Delaware primarily has to do with, there's a lot of tax benefits to it, and the corporate laws there, they protect corporations mainly in terms of how much information people can get about them. It's more just the corporate structure, like their corporate law, as opposed to the employment law side of it, if that makes sense. The laws they have dictating how corporations are set up and how they're managed, they're very favorable in Delaware. I don't know a whole lot about that, like the specifics of it, but Delaware is very much, it's the most popular state by far for incorporating. But a lot of states are starting to amend their corporate and business, formation statutes to kind of mirror Delaware to try to keep people, because you'll have, you only run your business in Tennessee, but you're like, well, let's incorporate in Delaware because we can save a little money and it's just a better setup for us. But that's been the case for a very, very long time. But that's a good point. You want to take a quick break, 5-minute break? Would that be anybody interested in that, or power through?
Yeah.
Anybody have any thoughts over there? Yeah, that's pretty emphatic. Okay, 5-minute break. I like the enthusiasm. Whoa, COVID, man. You can't be coughing. What's going on here? All right, so let's see, 7:55. We'll start back.
again.
Yeah.
Yeah.
I just tried. Amazing. Oh, thanks. Every time. I mean, really nice. Oh, the president's hard. Steve. My chat wasn't there. He's like it's no, hey, he's an animal. Mine is back on Wednesday. Why he'll definitely do next. Only one one. After that, practice, I'm like, this thing actually works. So what I said. It's still snowing, right? No. Oh, it's tomorrow. Oh, it should be alright. It should be alright. Where's the snow going?
Yeah,
Mine.
Wasn't great.
Still got to call out actually pay my tolls again. It was at least you almost started running. I mean, every time I passed the ball, it was just like, or I couldn't feel my feet, or I just wanted to just nervous.
Oh, really?
It was so wet. Oh, so cold. Wait, how are you doing? Even colder than Sunday.
So,
Sunday evening. Yeah. 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 -3, 4, 9. -3 in our house. I'm sleeping in my house. I mean, so bad it's all. Maybe there is even some just don't know. Mine is 13. How cold that is. I actually don't train first.
Now we're pretty busy.
Mary out there.
Yeah.
Yeah, let's get started here. All right, guys, we're gonna get started back here in just a second. Okay. So, ag gag, what does that mean? We got it in? Yeah. So what do they mean by ag gag?
They were recording, secretly recording, like.
Yeah, that's the case we're going to talk about. Now, but just generally, what does the term ag gag mean? So that's kind of the broad term they give to these large farms, you know, the legislators in Congress that they were in their state, you know, legislative bodies that they lobby to prevent anybody from talking about their agricultural practices. So it's like ag gag is like they're basically gagging any discussion about, you know, again, their agricultural practices or the, you know, how they're growing their chickens or slaughtering their chickens. You know, once you, I mean, I used to say that, like, once you know how sausages are made, you'll never eat them again. It's like, no, once you make your own sausages, oh man, good stuff. Love it. But so they had the case Animal Legal Defense Fund versus Otter. What happened in that case? Anybody in Jefferson City know? No. Okay. So there, and that's, you were kind of talking about this, is that they came in, they were videotaping what kind of farm was it? I can't remember that one. That was the beef one. That they were going in, they were filming all the horrible things they were doing to make sure that we get to eat our hamburgers, right? Anybody here vegetarian? Any vegetarians? I don't know. We'll ask again. But okay, so no vegetarians. That's good. Like, who wants to get a bad grade? No, I'm just kidding. I would never do that. But you know, killing it, you have to eventually. You got to kill these animals to get the meat from them, right? And it's never going to be pretty. You know, no matter how much you dress it up and like, oh, we massage the cows, and then they sleep on fine down mattresses and all this stuff. But then we do end up killing them and turning them into hamburgers, right? So there's that aspect to this whole thing. But with that Animal Legal Defense Fund versus Otter, what were they challenging in that case? They were challenging a law, right? And I think it was Idaho. Yeah. Now, what was the law? There was a specific crime that the Idaho legislator had basically created called interference with agricultural production, right? So they're saying you can't, if you go onto a farm or a slaughterhouse and you try to surreptitiously film it, or you try to, bring in, you're an undercover journalist and you try to expose to the world how they slaughter these animals or how they're taking care of the chickens, you've committed a crime and we can punish you. The state of Idaho will punish you for it. So the Animal Legal Defense Fund filed a lawsuit against Otter, who was the actual, I think he was the governor of Idaho. And they said, you are infringing, you have violated the First Amendment, by prohibiting people from conducting investigative journalism into, how these slaughterhouses operate, right? How did the court rule? Did they rule in favor of the Animal Legal Defense Fund, or did they say that, no, this new law is totally fine and does not violate the First Amendment? Anybody remember? No. Any guesses? Anybody want to guess how the court ruled? It is in the book. They said that the statute violates the First Amendment. And what the court said, now you get into the reading in the cases where they give you a lot of the opinion, it can get pretty dry. Legal writing's not the most fun stuff to read, is it? But the judge in that case, he said the remedy for misleading speech or speech we do not like is more speech, not enforced silence. So the court looked at this interference with agricultural production law as essentially it was enforcing silence. It was saying, they're going to keep all these chickens floating. They had the chicken meat floating in like just a soup to try to increase the weight. They would just float them in this soup of all the leftover chicken parts. I mean, gross stuff. But essentially, Idaho was saying, we don't care. They can do it however they want to, and you can't say anything about it. And if you do, we'll throw you in jail. That is a violation of the First Amendment. Now, what do you all think as far as the kind of overall, that statement by the judge, that the remedy for misleading speech or speech we do not like is more speech, not enforced silence? Does anybody disagree with that approach? Seems pretty reasonable, If you don't like what they have to say, well, you just say what you'd like to say, and try to have the more convincing argument, right?
I would say, like, what about in a situation where, like, it's a large media outlet misleading the public and, they have a position of authority and trust with the public that's been established, and the only people that are going against them are the public, and they don't necessarily have, like regular people.
Yeah, they don't have the means to combat. We don't have the platform.
Right.
My one Twitter account, what is that compared to, insert least favorite media outlet Twitter account, right? It's similar to the Citizens United question. It's that power disparity. I think that's an excellent point. There certainly is, like the mass media, like CNN or Fox News or whatever. They can just say something over and over and over, and most people are just gonna be like, well, if they keep saying it, I guess it's true, and they're not hearing any countervailing points or any, wait, that's not true. Here are the facts. No, I think that's an excellent point. But how do you regulate that, and how do you do so in a way that maximizes the ability of people and corporations, to exercise free speech?
I'd say, I guess that would be like libel and slander laws.
Yeah, it's okay.
I guess, in that case, that would be a court decision, which I guess consider more speech,
Mhm.
like a debate.
I think the defamation's an excellent example. Now, as far, what do you mean by court decisions? Explain that one a little more.
Deciding in court is libel, slander, slander,
Yeah. Well, defamation is like kind of there's libel and there's slander. Those are two types of defamation, right? Written and spoken. So defamation is one of the major exceptions to freedom of speech, right? So you can't just, freedom of speech, I can say what I want. You can't just go around and say, Don is a murderer. And that's not true, right? But you're supposed to say right. But, you can't say something that's not true about somebody and then fall back to the First Amendment and hide behind it and say, I can say whatever I want. No, if you've caused harm, if your speech has caused harm to somebody, then you're not protected by the First Amendment. Same thing for fighting words. That's another long recognized exception to First Amendment protections, which is you can't say something that's just so egregiously offensive that any reasonable person would just haul off and hit you in the face after you said it. You can't then go, he violated the First Amendment and when he punched me. They say, no, we call them fighting words for a very specific reason. You got punched in the face and that's your fault. Any other exceptions that that the courts recognize to First Amendment protections as freedom of speech specifically?
I guess you can't like shout fire in a crowded room.
Yeah, that's a very good one. Yeah. Because you're kind of you can create a panic. That goes back to, it's different from defamation, where that's harm to a person's character or reputation. But of course, defamation could lead somebody to go like hurt or kill the person that's the target of the defamation. But generally it's reputational harm. The shouting fire in a crowded theater there's very real risk of physical harm, people getting trampled, smothered to death or whatever. So yeah, that's another very good exception. Obscenity is an exception to First Amendment protections. You can't just say obscene thing, hopefully it's hitting recorded. I might have said something obscene. I don't know. But also the book gives child pornography as an example. That's, yeah, definitely. But that's extreme. I don't know why they had to bring that up. But regular pornography is not,
Wouldn't that all just be obscenity?
Yeah, arguably, yeah, it could be treated as obscenity. Certainly depending on where it's published, the forum. If you put it up on a drive-in theater, that's visible to the road, that'd be pretty obscene. But so there are certain, content-based restrictions. That we say there are certain types of speech that are just too harmful, and therefore we're not going to allow them. Interference with agricultural production is not one of those. People can say, look at all these horrible things they're doing to these chickens. And then someone can turn around and post a picture on Twitter of a big old plate of wings and be like, yeah, but they're delicious. And that's the debate we have about it, right? So debate is good. And they say the remedy for misleading speech or speech we do not like is more speech, not enforced silence. And of course, now we see some of the social media is taking a more aggressive approach in silencing, I guess the more aggressive tweeters and Facebookers or whatever you call them. And that's an interesting kind of topic there. If should they be restricting, should they be, blocking accounts as they're doing now? I mean, does anyone think that they've gone too far? They're doing just enough? They're doing not enough? Nobody wants to expose their thoughts on that. I don't blame you.
Disenchanted with the whole process.
Yeah, it's pretty disheartening, isn't it? It's like, hopefully everybody's just like, we don't even care what these people have to say. But should we be enforcing silence? Should we say, should these companies, and that's the interesting debate here. So we're talking about the law. Idaho says, we'll put you in prison if you say these things. And the judge says, nope, that clearly violates the First Amendment. Twitter, Facebook, various other social media, they're not the government. They got a lot of control. They're very widespread, but they're not the government. So it's arguable, does the First Amendment really apply to their users, to the people that voluntarily choose to use their platforms? What do you all think? You think you want me to wrap this class up, don't you? But too bad. We still got stuff to talk about. So it is, you see kind of where these themes kind of interplay with what's going on right now. And it's not necessarily here we got the ag gag case actually has a lot of similarities to what's going on right now with social media. Now there are some very obvious differences, but the concepts here are, what that judge said, it's something to consider. If someone says something misleading or you don't like what they have to say, well, convince people that they're wrong rather than saying, you know what, you just can't talk anymore. You had a question?
So it's basically somebody that, like, I can go post something about Nike saying they use child workers to make your shoes, so you shouldn't buy it, and it's false, as far as I know. And then Nike comes and sues me. Technically, they really can't because it's not with the government, right?
No,
It's social media.
yeah. What you're saying, if you said that and Nike just sued you for that tweet, or if you got blocked?
Yeah, I guess Nike was trying, it got a lot of attention, it made the news, and it got a lot of attention from it.
Yeah.
People are starting to question Nike because I had good facts, even though I'm still lying about the whole thing. I just made it look like it was all real. Or I could be lying. It could be true.
Yeah, if it is objectively false, if you were lying, you knew you were lying when you said it, Nike would have a cause of action against you, likely. Now, would they do that? No, they'd probably just try to pay you off quietly. get you to take the post down in exchange for 10 grand or something like that, just purely because of optics, not because of any legal reasons. But, if you say, hey, Nike's making their shoes with, underpaid or unpaid child labor in, various countries, that may not be false. Who knows? But they would have to, in defamation cases, if you were sued for defamation, the truth is the ultimate defense. But how are you going to prove? You're going to fly over to, Southeast Asia and investigate all the factories? Nike's not going to let that happen. But you don't typically see corporations suing people for defamation. Usually they don't really need to. It's really just a PR thing for them. They just pivot to, that's a big business word, right? Like pivot. I had a friend who was in an MBA and he kind of used that word all the time. But, they would just set up a PR campaign and try to, discredit the person making those statements. Defamation cases, you're typically going to see individuals because again, the harm is usually to the person, the individual. But that's a good example. I mean, that would be one that would be, there wouldn't be a clear-cut answer on it, but it'd be interesting.
Do social media platforms and their terms of use basically give themselves the right to silence people?
I have no doubt that is the case. There's Halloran Hilton Hill's a big radio guy in Knoxville, and he was talking. He talked about. I don't listen to him that much, but it seems like every time it pops up on the radio for 5 minutes, he's arguing with somebody about social media, and he's like, the terms and conditions. It's right there in the terms and conditions, and it is, and nobody reads that stuff. But you say you can't get all mad and be like, well, First Amendment. Well, Facebook isn't the government. Facebook's a private company. You voluntarily chose to use their platform. You did something that violated their terms of service, and they blocked you. They can do that. Question is, should they be able to do that? That's the kind of the interesting question. Well, it's
the way in which they do it. I mean, it's the algorithm that turn you towards and tend to bolster and fortify a particular position, which polarizes the general population, which can be fighting words if taken to an extreme.
well, you can see a lot of fighting words on social media these days, right? And that's why they're trying to block them.
But it's self-promoting. I mean,
Yeah.
they designed it that way.
Yeah. And now they're seeing kind of the danger, and so they're trying to, like, oh boy, we screwed this up. Let's just start blocking people, and that'll fix it. Probably not. I think the real question is with Twitter and Facebook, particularly, kind of the social media giants, is it's gotten to the point that what viable alternatives are there, and do these, by engaging in this sort of, we're going to pick and choose, who can say what on our platform. That doesn't probably implicate the First Amendment, but it certainly implicates whether these people have now become publishers rather than simply platforms for people to engage in online discussions, right? So if we're going to pick and choose what can be there, should they still then enjoy, liability protections? That's a debate that will rage on for at least a couple more years, if not a whole lot longer. But it's just something that's interesting to think about. But you got to remember, social media, it's not the government, so they don't have to give you the full scope of your First Amendment rights, whereas the government does, right? Do you remember the Ceballos case? Ceballos, however you pronounce it, Ceballos, where he was a federal, I think he was a prosecutor, he was an attorney, and he made statements, indicating his disagreement with, I think a defense attorney had called him up and said, listen, this warrant you're serving on my client is no good for these reasons, gave him a bunch of documents. He went and investigated it and was like, yeah, that's right, it's no good. And tried to go basically get this case dismissed. And he said, we're not going to pursue this case any further because, the warrant we issued was based on bad information. And the higher up said, no, we're going to keep pursuing this case. We're going to charge this guy, and you're going to keep quiet about it. And essentially he ends up getting fired, and he says, they violated my First Amendment rights. And remember, he's a federal prosecutor. He's an employee of the government. And he says, my First Amendment rights have been violated by you restricting what I can say. How did the court rule? They did rule against him. But why? I mean, that's not a bad argument. Even though he worked for the government, and the government has to accord you your full constitutional rights, right, including freedom of speech, in the context of in your capacity as an employee and in engaging in your official duties as an employee of the federal government, you do not enjoy the same First Amendment protections. Now, if he'd gone out on his own time and said, that case, this is based on bad evidence, case is crap, I'm out of here, this is stupid. There's nothing they could do. But when he goes in his official capacity as a prosecutor, they can exercise a certain degree of control over the employee's speech. Again, even though it's the government, and the idea behind that is the government has to be able to exert a certain level of control over their employees, and they can't just have a bunch of wild cards hiding behind the First Amendment and saying all kinds of crazy stuff, right? Or disagreeing with how the government's proceeding on a certain case. So they said here the government can restrict employee speech when that speech is made pursuant to official responsibilities. So you see, the First Amendment is not as strong as you'd like to think. And there are a lot of people that will go running to it and they'll say First Amendment when Wendy's blocks them from their Twitter account. No, that's not the First Amendment. That is only the government. Now, whistleblower, and that's different, but that's,
But then you gotta find the provisions in that
Yeah.
state.
and you have to have, I blew the whistle on them because they said something I didn't like. The court will say, well, fantastic, and you got fired and you don't get any money. Case dismissed. That's the whistleblower. You've got to actually, again, like you're saying, you've got to know, okay, is this conduct that this particular state that I'm in says falls within the whistleblower protections. So again, like New York, it's public health and public safety is all they really care about for whistleblowing. Montana is pretty damn broad, right? So we're getting close here. All right, hold through, guys. Workplace surveillance. And when we're talking about social media, I didn't even mean to do that. Look at these segues. Facebook post, Deborah Elling or whatever, against Monmouth Ocean Hospital Services. This is a nurse, right? And she posted something on Facebook. Does anybody remember what she posted on Facebook? There was some 88-year-old white supremacist went and shot up the Holocaust Museum or something, terrible, that everyone would be like, that's awful. This guy's horrible. Well, she posted on there after he'd shot somebody and then he got shot, but it was non-life threatening. And they showed the paramedics running up to save the 88-year-old white supremacist that just shot a bunch of people, right? These paramedics are doing their job. Their job is, we don't care what you've done, who you are. We're here to render assistance and to keep you from dying if we can, right? So she posts, and she's a nurse for a hospital, posts on Facebook, I got 2 questions for the DC, paramedics. First off is like, why didn't you just let him die? And second off, like, this was a great opportunity, for us to rid the world of one more white supremacist, something to that effect. And then she said, oh, and to the guards, go to target practice. Basically saying this guy should have died because he's a white supremacist. Now, this guy's a murderer and has objectionable viewpoints. Does that mean that paramedics shouldn't go save him? No, but that's not the question here. The real question is, she posts that on Facebook. Her Facebook is set to only her friends can see what she posts. So it's not a public page, right? And does anyone remember what happened? How she ended up getting fired over that Facebook post. And, of course, their reasons were, you've exhibited a disregard for, potential patients, people in life-threatening situations. That's unacceptable for anyone who's going to be a nurse. You have to render aid to people regardless of who they are or what they believe. That's why she got fired. But the point is her Facebook post. How did her employer find out about it?
A friend shares that post. Their friends can see that post.
Mhm. That's sort of what happened. So one of her friends, she had like 300 friends on Facebook, and one of her friends saw that went to her employer, Monmouth Ocean Hospital, and said, look at this crazy post from one of your nurses. And they said, oh, goodness, that's pretty wild. We're going to fire her. You can't be saying, you can't, say, hey, kill this person or don't render him aid because we don't agree with his viewpoints or because he's a murderer, which is like, it's hard to, like, maybe she's got a point. But again, she's not supposed to do that. So did the court find that there was an invasion of privacy in the employee's Facebook account that the employer found out and fired her over? No. It was, there was a specific act they looked at, the Stored Communications Act, that basically says if you've got something that's stored electronically and it's not accessible to the public, then that is a protected communication. And if anybody gets their hands on it or publishes it without your permission, they violated this act. But there's an exception to it, the authorized user exception. And that is if you've got, and basically in the context of Facebook is, if one of your Facebook friends sees it and you posted it, and obviously you want all your friends to be able to see it, but you've restricted your privacy to where it's only your friends can see it. If your friend takes that and he's an intended recipient of that communication, he can take it, and he can go right to your employer and say, look at that, look at this, look at what you posted. You need to fire her. Or maybe he didn't say that. He said, look at what you posted. And they said, well, we need to fire her. In that case, the court said, no violation by the employer. They haven't violated the Stored Communications Act because an authorized user brought it to them. Now, the court said it would be different if they had gone to the friend and said, listen, we've heard that this lady's been posting crazy stuff. We know you're friends with her on Facebook. You need to look it up right now. We want to see what she's posting. That's different because then it would not be an authorized user. They'd be compelling him to look this up. But the court said because he willingly and voluntarily went and provided information that the employer didn't ask for, and did not seek out, then that he was an authorized user, and what he does with that information, you've authorized him to do it. So, too bad. Your friend, let you down. But that's, you do see in that case how because technology is advancing very rapidly, right? It's just constantly changing. And laws are always just trying to catch up to the changes in technology. They're trying to adapt and catch up to it. And the court actually said in there, I think the judge, he said, most courts, including this one, would prefer that Congress update the statute to take into account the invention of the internet. So you do have, pretty funny, these judges are kind of funny, right? But what you see is they're trying to take laws that were written or enacted under a different set of, different technology was available at the time, but they can use it to apply it to, okay, now we've got Facebook and we can apply the Stored Communications Act and the authorized user exception to the context of Facebook. But the court recognizes it's not a perfect approach and that, the laws have not caught up to address directly social media, Does anyone think that there needs to be any laws with respect to social media, regulating social media in terms of, in like a similar case to this one? Would a different law have led to, if they had updated those laws and brought in Facebook, would there have been a different result? Should there have been a different result? Does anyone think this lady should not have lost her job?
I think the reason she lost her job, the fact that she would let somebody die, that kind of goes against the moral code of the nurse. But the fact that she lost her job because of the Facebook post, I think that's a little bit unfair. But it might be in their terms and conditions, when she signed the papers to be an employee. I don't know.
Yeah. Well, it's an interesting, you have a question?
Well, so yeah, different context, as my employer tells me, I have no presumption of privacy when I'm on their networks, working on their systems.
Hmm.
Now, if I'm on my phone and I'm off their network, does that still apply? Does my job, if I'm a nuclear reactor operator, or if I'm an ambulance driver, or whatever the case might be, and I'm actively engaged in my job at the time, and I'm violating some policy, does my employer have the ability to go in and say, were you violating this very important aspect of your job?
Potentially.
And do they have the ability to go in there and dig that out then?
Yeah, that now right now, as it stands, it would be more than likely dictated by whatever employment agreement that you had with your employer. They can make it, as part of being an employee here, you will grant us access to your social media accounts. You will grant us access to your phone, or we can, track your communications. The book talked about 100 years ago when Henry T. Ford is setting up the modern American workforce, right? He would have people going around at like 9 o'clock at night and knocking on workers' doors and be like, hey, turn the lights off. You all need to be going to bed so you can get up early and make me some cars, make me some money. That's obviously technology was different then. They weren't able to just spy on people's phones. A lot easier to keep track of people now, right? But it's the concept. I think the principle is still the same as how much do employers need to know? And it probably will vary. Well, it definitely should vary based on what the job is, what your responsibilities are. So the nurse, if you're going around saying, we should have let this person die, well, we probably don't want this person to be a nurse. And if you're nuclear, if you're in charge of a nuclear reactor, they probably don't want you to just scrolling through Facebook while, all the lights are going off in the Simpsons or whatever, the reactor's melting down. And you're just like, that's, so there are times when it is appropriate, but, the flip side of that, and you look at it, especially now with the pandemic, so many people working at home, is they know where you are and they can reach you. I worked at a firm where I'd get emails at, 9 o'clock at night that weren't even important. It's not like there was something coming up the next day or anything. They just email you at 9 o'clock at night just because they could. What level of communication, or more importantly of surveillance, is appropriate, and if any?
Get back to your question initially, that's a minute ago. Even if they updated the laws, it's not like the employer went out seeking information.
Yeah.
Going through their account, violating anything.
Yeah.
I don't think it would have necessarily changed anything.
No, probably not. And again, that was what the case turned on, was they weren't seeking this out. It was someone who, you wanted your friends to see this post, and one of your friends said, I'm going to let your employer know, because what if you suddenly think that I'm, an unsavory character, and I'm sitting there with bullet wounds in me, and you decide you don't want to patch me up? I want a nurse who's going to patch me up. Did what? Yes, she did. She sued the employer, and she lost. Well, she would have lost that case too.
Well, her friend if she did sue her friend, she did in a way violate her, I guess, privacy terms by sharing this post with somebody that's not her friend.
Well, once you've put it out there on Facebook, and this is a good life lesson, is once it's out there, even if it's just restricted to your friends, once your friends see it, you can't put the cat back in the bag. They can kind of take it and do what they want with it. Yeah, unless you put some disclaimer, this is not to be republished or to shown to anybody other than my friends on Facebook under any circumstances. You're probably not gonna have a lot of friends on Facebook for much longer. And you're like, this guy's he's awful. But also, this doesn't fall into the ethics question, but from a practical standpoint, suing your friend versus suing a hospital. Your lawyer is going to say your friend probably doesn't have any money, so we're not going to sue him. We're going to sue the hospital. They've got money.
You can block a friend.
Yeah, that's. And be like, listen, just block them, delete them off Facebook. Who cares? But yeah, that's they're practical realities to And I've had clients that they want to sue. It's the principle of the matter, and I'm like, this is not economically. This isn't very smart. We should not be pursuing this case. And be like, it's about the principle. 2 months later, they've calmed down. They get their first bill, and they're like, well, listen, we got to keep the billing down. Well, principle is only lasts so long. But when it comes to the bottom line, you start to Yeah, you're like, wait a second, I'm not that mad about it anymore. Lawsuits also take so long that your emotions are they're not gonna be there the whole time. So, and we're almost done here, folks. Just bear with me. But does anybody recall the state of New York versus Walmart, the Walmart case? You might remember what happened in this case. What Walmart, so this person was, there was an employee and she was married. She, I think before getting a divorce, started dating, or marriage fell apart and she went and started dating one of her fellow employees. And Walmart said, you're both fired because you're violating our internal policy that says there won't be any relationships or fraternizing between employees. We don't want that to happen. And in that case, it was a case of statutory construction. Essentially, there was a state law that said, employees can't be fired for engaging in recreational activities outside of the hours of employment, hours in place of employment. And basically, the simpler one would be they fired you because we heard you were playing Ultimate Frisbee last Saturday. We think Ultimate Frisbee is for losers. You're fired. That would clearly violate, that'd be a recreational activity. The question is a romantic relationship, does that fall within recreational activities? Now, this specific case, the facts of it aren't that important for what we're doing, but it is important in terms of statutory construction, how courts are going to interpret the law, how they're going to interpret what a legislature meant when they chose the words they did for a particular statute. And here the majority said, and I may have them backwards, I think it was the majority said, listen, going and dating somebody on your own time does not fall within a recreational activity. It ain't playing Frisbee. We're talking about, this is heavy stuff. It's not a recreational activity. Therefore, they're totally fine firing her. Dissent says, recreational activity, basically it's narrow construction versus broad construction. The dissent said, no, this should be read more broadly. Recreational activities should clearly include relationships that people have on their own time with their friends and romantic partners, etc. And therefore, I would have ruled, the dissent said, the court should have ruled that, it was a wrongful discharge, because the purpose behind the statute was we don't want the businesses, we don't want employers interfering with their employees, daily lives outside of the workplace. And that is, you'll see that theme will come up again, statutory in terms of statutory construction, the kind of the narrow construction. Okay, we're going to take just the words they use and we're going to construe this as narrowly as we can, versus you have the broad kind of, we're going to take an expansive view. Okay, we know what the legislator was trying to do. We want to read this as broadly as possible. And that'll come up. I don't know if the Supreme Court, two cases we got coming up for the case briefs, I don't know if they've addressed that in there, but it is an important thing that it'll come up again. How courts interpret the law will not always be the same. Different judges can interpret the laws in different ways, which can lead to very different results. In that case, it would have been, the dissent would have ruled, hey, this lady, she was wrongfully discharged and she gets some money or she gets her job back, whereas the majority says, sorry, lady, you don't fall within our narrow definition of recreational activities. And now we're going to end with cell phones again. The point you had made about, I think, Mary, you had made the point about the government, how the government can use cell phones. So we're talking about tracking, right? And so businesses can track where you are to figure out where you're going to next and send you a quick ad for some McDonald's before you pass it. You're like, oh, McDonald's, you turn in, if you hadn't seen that ad, maybe you wouldn't have wanted that quarter pounder. But the government, now obviously the government is subjected to the Fourth Amendment, which means they can't make any unreasonable searches or seizures, without a proper warrant issued upon probable cause. And cell phones creates, particularly these kinds, smartphones. We used to have cell phones that were literally just phones, right? They were just, you could make calls wherever. You had service, I guess. But with smartphones, I think it was the Riley versus California case, and that's where Chief Justice John Roberts he said, well, a cell phone could just as easily be called, they could just as easily be called cameras, video players, Rolodexes, calendars, tape recorders, libraries, diaries, albums, TVs, maps, or newspapers. You've got unprecedented amount of information at your fingertips with the phone. But each phone is not just, we can all access the same information. It's your information. What have you searched for? You're searching for heart attack symptoms. And this guy's a hypochondriac. He thinks he's having a heart attack, every couple of weeks. If you look at my Google, it'll be like heart attack. I'll be like, nope. But if the government is able to just look into your cell phone, they could uncover basically everything about you. That's not true of every single person, but it's becoming increasingly true of everybody, that our lives are lived in large measure through our smartphones. They hold all the pictures that we've taken of stuff. They've got, again, all the stuff you're searching for, what your interests are. It's got banking information in there. Most of us are going to have access to our bank accounts through our phones. And so when the government, in the context of a criminal investigation, if they say, hey, we want to look at this guy's cell phone because we think he used it to make calls to sell drugs, as an example. They get this open-ended warrant and they look at his phone and they just start searching through everything. They go through all his pictures and they're like, oh, we might be able to get him for another, piddly little crime. Let's up the charges. That looks like a misdemeanor there. He was looking up, can't think of a good example right now because it's late, but there's too much information there that the court says in Riley versus California. They did say, the court did rule, you've got to have a very narrowly, like a restricted warrant. If you're going to search somebody's phone, it can only be for particular things that are, articulated within the warrant, and you can't go beyond that scope. And you find anything else beyond that, well, it's a warrantless search and seizure in violation of the Fourth Amendment. It's out, right? You can't use that evidence. And I think he actually, at one point in the majority opinion, he says privacy comes at a cost, and cell phones, they hold all the privacies of life. And so they're looking at this in terms of, do you all agree there? Do you think that that's a reasonable way to approach smartphones and, how much the government can look into them? No?
If it's not the cell phone,
No, it's true. But the cell phone's going to be, because the government is looking at my cell phone. They're going to be things that are only going to be found on my cell phone. Also, there are going to be searches that'll be like search history will only be on that phone. It's not like you can just hop on Courtney's computer and be like, Michael's cell phone search history. I'm not going to be able to find it, but I will find it on there. So that's why they've got to, and that's where you see laws that were enacted. Fourth Amendment, that's 1789, that's 231, 32 years ago. But you see how it applies and adapts to our changes in technology. And you say, okay, the law is recognizing, the Supreme Court is recognizing that how important these have become, how ubiquitous they've become to us. And it would essentially amount to now, they get just an open-ended seizure on that, whereas 30 years ago, they get a warrant and you can tap the phone lines, but they can't do anything else. Here, they get access to the phone, and that's like I said, it's your library, it's your all your search history, it's everyone you've ever contacted in the past, however long you've had that phone. And then did you all read the Anita Allen? I think that was the last part of the chapter 4, talking about, privacy, the great privacy giveaway, I think she called it. And that's kind of social media, people oversharing, which seems to have fallen off the past few years to an extent. People used to say, going to the grocery store on Facebook, and it's like, no, nobody cares. Even you don't care. But, she's talking about how people are just kind of giving away their privacy, and that it's not a good thing. We need to have privacy in our lives. And that's why it's important that we have things like the Fourth Amendment to make sure that we can protect elements, protect our privacy to the greatest extent we possibly can while still enabling the government, to prosecute crimes effectively. But, Anita Allen says, privacy is a requirement for our freedom, our dignity, and our good character. And so that raises the question of, do we have a moral and ethical obligation to protect our own privacy? Does anyone think that we don't have an obligation to protect our own privacy? Mhm. And so should we be taking greater steps as we, gosh, a cell phone makes everything so easy, but should we be taking greater steps to protect our own, or not even protect our privacy, but just to make our lives more private?
I think we do have some obligation, but the means that the government has, whether it's working with cell phone providers.
Yeah.
I mean, there's nothing you can do that can protect against that.
Yeah.
I mean, it's beyond your.
Well, there is. Don't put so much stuff on your cell phone, right? You need to, no, you don't go that far. Who has that kind of time? Probably you should. There's an idea of, Carson Newman is a Christian school, right? The book of Matthew, there's the example of, when you're giving alms, don't do it publicly, right? Do like the Pharisees and make a big show out of, I'm giving, you just make sure everyone's watching. You hand $5 to the homeless guy and you're like, did you get a picture? Here, I can redo it. Give me the money back. You want it to be, it takes away from the moral benefit you've gained from that is really lost, because it ultimately just becomes you are trying to get attention, right? So we want our acts to be, we want to protect our privacy. You want to think like the private alms example there. And then, I think Anita Allen, she actually gave the example of, hey, if an employee sends an email to a few of his co-workers and says, look, I've got highly advanced colon cancer. I'm going to be stepping back. I've got to treat, to work on treatment and to spend time with my family. This is real tragic news. And you're like, well, gosh, that's a certain level of, you confide in your friends, that's fine. And then she says, take that a step. What if he comes in and says, here's copies of my x-rays and my MRIs. Like, this is my last visit to the doctor, was horrible. I've been losing my hair. I'm puking and pooping on myself. And that's oversharing, right? And you've actually you've offended your friends, and you've reduced your own dignity by, oversharing what should be left private. Does that kind of make sense? So there's a lot of, that's 4 chapters we went through today, kind of broadly. Does anybody have any questions about any of the stuff we've covered today, or any of the, including the discussion posts? Nobody's got any questions?
For the discussion post for the theological, I didn't post a post because you said we were going to talk about it here. But
Yeah.
Do I have to?
No. That's so, well, yeah, that's to reiterate. I guess you weren't here when we first started talking about it. So I did it. That's why I was like, oh, I already addressed that, but you weren't here. No, going forward, starting this week and going forward, you still do need to read what is on the discussion post, but you don't have to post on there. The discussion will be here. And now, guys in Jefferson City, I know it's tough, and it's hard for me too. I get very caught up with the people that are right in front of me, but do make sure that you're, if you ever want to chime in, you just start yelling, hey, professor, if you got something to say, please do say it. We want you to participate in the discussion. I want you to participate in the discussion. It helps you all understand the material better when you or your fellow classmates, can bring different perspectives to it. I certainly don't have all the answers, and I'm, sometimes I just start rambling and who knows what I'll say. So please interrupt me as much as possible. But discussion, your participation grades, obviously attendance factors into that, but it's primarily actually discussing what we're talking about. So yeah, but to answer your question on Canvas, you don't need to do the posts anymore, but you do still need to read the material for each of those posts. And so, does anybody have closing thoughts? Anybody? Sure.
So for the case brief, I know you said you can't go over 6 pages, and when I wrote mine, I literally had maybe two lines on the last page. But I shortened it to where it's exactly 6 pages. And
Okay.
let's say when I-
Yeah, please don't go over 6 pages. That's, yeah, don't, if, make it work, you know, and you can, and a good thing to do with your case briefs is, you know, you just look at, and this is Grammarly is very useful for this, you know, if you're using like, you know, if you're using passive voice or you're using more words than you need to, you know, you can shorten those things up if you're having that issue. But certainly don't feel like you have to have 6 pages. If you can get it out in 4.5, 5 pages and you feel like you've said everything you need to say, then that's fine too.
It's okay to have one paragraph for, let's say, the issue.
Yeah, that's, I mean, feel free to, you can have more than one, but one is sufficient as well. Now, if it's a big old long paragraph that's 1.5 pages long, I'm going to probably mark in there and be like, you need to break this up into a couple of different paragraphs because you want to make it, the easier it is for me to read, the better your grade is going to be. And that is true both in terms of your citations, your grammar, your sentence structure, all of that. That's going to be, the easier it is to read, the easier it is to get a good grade.
When is the next case brief due?
I think it's due Sunday. Yeah. It is due Sunday. But I tell you what, because I'm such a nice guy, I can make that due next Tuesday because I think we'll have a week off. I tell you what, I'm not making any guarantees. I'll send a class email for now. It's due Sunday at midnight, but I'll think about it. That's the best I can do. Is that fair?
It's a big one.
Yeah. They're all, and the Supreme Court opinions are not much fun to read. They aren't.
There's a lot of not fun to read in this one.
Yeah, the textbook isn't much fun either, but that's okay. You know. You have another question?
If we turn it right at 12, that's specifically.
Yeah, 11:59 would be ideal. So I've been very lenient mainly because, you know, it's been kind of a weird start. But going forward, I do want to make sure. Now I've given an extension. I got 6 people that I don't have case briefs from. And I'm giving you till Tuesday at 6 p.m. to get them to me if you haven't gotten them to me yet. You will get slightly penalized for being late, but you'll still get some credit. If you don't turn it in, you'll get it by then. By Tuesday, it's tomorrow at 6 p.m. You're going to get a 0, and that's not good. But going forward, I have been lenient on people getting stuff in a little late, but going forward, deadlines are very important. You know, if I file an appeal a day late, I don't get an appeal, and then I got a client, then I got some major problems, right? So being professionals in the business world requires that we meet deadlines, you know, when they fall. So I've been lenient, but going forward, you need to make sure that everything gets in at the time stated. Now, that's always subject. If I send a class-wide email and say, hey, everyone gets an extra day because I'm just feeling nice, then the email controls. But, you know, do get things in by the deadline I've set for them. Okay. Now, if there's, of course, if you've got extenuating circumstances, if you let me know in advance, don't tell me the next day, oh, hey, I didn't get this to you, but you know, something crazy happened. But anyway, here it is. You know, let me know in advance, and I am reasonable. But I will not be lenient going forward, just reasonable. How about that? Is that fair? Okay. Now, any other questions? Case briefs. Does anybody have any questions about case briefs?
First section of the case brief where it's like very, it's the very first section of the case brief. Is that?
The syllabus? Yeah. Okay. And that's another thing I talked about beginning of class. You don't cite to the syllabus of the case opinion. And your citations are going to be, you know, 531 US, and then it'll begin at page 1 on the majority opinion. It'll do the same for the syllabus, but do not cite to the syllabus. You will get penalized if you cite to the syllabus. Not for this one. I'll be lenient. Again, first one, I'm going to be very lenient on the first case brief, but my goal is going to be to include notes to everybody that are, you know, personalized to each case to say, you need to watch out for this. Don't cite to the syllabus, whatever the case may be. But going,
How do you cite to the dissenting then? or
the
to
dissenting, so what you'll do, because the page numbers do start over, right?
Right.
So it'll be like 531 US at 1. What you do is in parentheses, if it's, Kagan, you say Kagan, comma, J, dissenting in parentheses. So it's like the parenthetical after the citation lets me know you're citing to the dissenting opinion rather than to the majority opinion.
Can you send us an email with like example citations?
If you look at the sample case brief, I emailed that, might have been my first email to the class, one of those emails, but it's the attachment. I sent like the syllabus and the first and an example of a case brief. That will have, if you'll look, because there's actually a section where you talk about dissenting opinions, right? And you'll see in there, just look at the example sample case brief and the way that they have their citations in that one are correct. And that's what you're going to do.
Parentheses, could you give us or he, whoever, you gave us an example, like this is the long one they have to do for the first citation, and you have to use a shorter one.
Yeah.
The shorter one that was on the website, it has parentheses, the last name, comma, page number. But they didn't have parentheses, they just had the 570 underscore US, whatever.
Yeah. So that's a good point, because when you're talking about the dissenting opinion, you first cite it, you say, main community in italics, comma, 546 US at 1, Kagan J dissenting. After that, as long as you're still citing the dissenting opinion, you can just cite to the page number 546 US at 3, right? Does that make sense? The long one, so that's the first time you do it. So the first time you cite the dissenting opinion, you make it clear, I'm citing the dissenting opinion here, then you can just do the shorthand. But if you go back to cite the majority opinion, you will have to, to do the long cite and say, in parentheses, whoever, and I can't remember who cited what, it all runs together. But does that make sense? Is that and does that, y'all in Jefferson City, does that make sense as far as the citations go? Okay. Okay. Now you'll kind of have to, you just use the one you did before as your template to, this is how you do the citations, and you just take the same approach, but you're just plugging in different numbers and different case name. And I'm going to try to get everybody's graded case briefs. I'm going to email them to you individually with comments and your grade. Now the first case brief, I think it's 80 points for the first case brief and then 110 for 2 and 3. So while I am going to be more lenient on the first case brief, it's the lowest overall possible grade. So 2 and 3 are going to be, they're going to be more important and more detailed. And so it'll depend. I've got a hectic work week suing people. So yeah, I may end up giving you all a brief. Again, no promises. I'll email you on this. It's still due Sunday at midnight, but I may give you, I don't want you all to have to do the second one without having seen my comments on your first case brief, because I don't want you all to repeat mistakes that you might avoid if I told you in advance. So we'll just kind of see how that plays out, see how much of the grading I can get done tomorrow, and then I'll let you all know. So if there's going to be an extension, it won't be a long way. It'll be, at the longest, it would be Tuesday at midnight. But again, I don't want you all to have to, I don't want to see repeated mistakes. That's as much for my benefit as for you all's, because I don't want to have to read the same mistake again. So any other questions, comments, concerns, complaints? Save that for the last class, right? But, well, it was good to see you all finally. And, I've got, you all can email me. Again, I'm not the quickest on getting to my emails, but you can also text, call if any questions or issues or anything like that. But let's just make sure we get the reading done for next week. I want to see a little bit more good discussion here. It's not really fair to you all, because it's like I kind of look here and I look over there every now and then. But I'd like to see some more talking out of the Jefferson City group would be good. And I will see you all next week.
Thank you.
Thank you all. Oh, yeah, that's right. What was your question? I can't remember what it was. Yeah, of course I can.